Yes,
I beg to mention, my lord, item number 14 of today's list.
14.
Yes, my lord. It's a hearing matter, my lord.
Yes,
On behalf of the respondents, my lord, we are required to file an additional affidavit, bringing on record, my lord, certain vital documents.
2016.
2016, I can understand, my lord. Yesterday, we had brought all the records. In fact, on the last occasion, this honorable court had directed me to get seizure of all the records.
Hmm.
And my lord, an observation was made, my lord. If required, my lord, it would be taken up for hearing today itself. But yesterday, when the records have been, my lord, called for, on going through the records, I have found that, my lord, I am required to file an additional affidavit, my lord. Because
It's regarding acquisition.
acquisition and the compensation statement, that compensation statement is not on record. So I need to file an affidavit, my lord. Kindly accommodate me for at least 3 weeks, my lord.
There's a discrepancy in the calculation.
If it has been filed by the state, my lord, wherein the subsequent statements have been annexed, but the very compensation statement is not a part of the record. But they will get a chance to rebut, my lord, if any, against my affidavit, my lord. They will not be prejudiced, my lord.
Okay. Mr. R. Borpujari, Learned Standing Council Revenue Department submits that the state has to file an additional affidavit bringing on record
The compensation statements.
the statements of the compensation statements. Therefore, press for listing of the matter after 2 weeks,
Can it be, my lord, in the second week of February, with all respect?
3 weeks, 2 weeks.
Lordship, date. Anyways, Lordship, date
3
may be
weeks.
fixed, Lordship.
Mr. Prayer, the submission of the submission, the said submission is not opposed by Mr. Hmm?
BP
Your
Sharma. BP Sharma.
Hmm?
BP Sharma.
BP Sharma,
Lordship.
appearing on behalf of
Sir,
J. Roy,
J. Lordship.
and senior counsel for petitioner. Mr. In view of, let this matter be listed after 3 weeks for filing additional affidavit. Mr. Considering that the matter is of 2016, no further adjournment shall be granted on the next day.
Lordship, date may be fixed, Lordship.
We'll see after 3 weeks. It will be listed. Just give the date, whatever. It's there.
11 February.
I'm
Deeply
so
obliged.
obliged.
Your Lordship, item number 15,
Item number
15, 15.
15.
Sir, prayer for adjournment.
Why?
Sir, we have taken the concern of the respondent.
So once you taken the consent of the respondent, we should grant the adjournment automatically.
Sir, due to some reason, we would.
What is the reason? Anyway, on the prayer of Mr. MS,
Sir, Harish Gupta. Harish Gupta.
what's your name?
Poojarani Chaudhary.
Appearing on behalf of?
Chandrakanta Goleta.
Huh?
Therefore, the petitioner, my lord, I am appearing for respondent 1, 2, and 3 in this case.
No, who is
Is Gupta is appearing.
Harish Gupta, sir.
okay. MS so and so, Learned Counsel appearing on behalf of Mr. H. Gupta, Learned Counsel for petitioner. Submits that our senior Mr. Gupta has some personal difficulty, therefore prays for adjournment of the matter, which is not objected to by Mr. P. Hazrika for respondent on 2, 3. Mr. Accordingly, list this matter after 3 weeks
Obliged.
as agreed.
Like, sir.
As agreed.
Wait, please, Your Lordship. With the consent of the other side, I beg to mention item number 3.
3.
I'm for respond number 14 and 15, my lord. It may be listed after 1 week, my lord.
On the prayer of Mr. Vijay Talukdar. Then counsel for respond number 14 and 15, list this matter after 3 weeks.
Obliged.
May I please, your lordship, with the consent of the other side, I beg to mention item number 10 and 11, lordship.
10?
10 and 11, lordship.
Ha.
Senior could not be present today due to some personal inconvenience, lordship. Kindly matter may be adjourned for the enlist on later after 2 weeks, lordship.
Report petitioner,
Yes, lordship.
only prayer by Ms. So appearing on behalf NK Kalita. Deka or Kalita?
Kalita, lordship.
NK
After 2
Deka.
weeks, lordship.
Submits that her senior has some personal difficulty today, therefore prays for listing after 3 weeks. Whereas the law list after 3 weeks.
With the concern of the petition abatement, item number 5. That will be
Item-
taken after 3 weeks. In the meantime, I will file my affidavit.
Huh?
Item 5.
Yes,
I was supposed to file affidavit, my lord. Lord, allow me 3 weeks time, I will file my affidavit, because
you are granted.
instruction is not full, my lord.
Huh?
Entire instruction I have not received. I have received,
The same submission you made last occasion. Your instruction is incomplete.
I found it that
It's
not sufficient-
incomplete.
Not sufficient to file an affidavit, my lord.
That's why you had made the same submission last occasion. On the prayer of Mr. S. Bora, Learned Standing Council GMC. List this matter after 2 weeks for filing affidavit.
Actually, there is an interim audit.
Interim order passed earlier and continue.
Obliged.
May I please, lordship, I beg to mention item number 9.
Hmm.
Senior went off to station for medical purpose. Kindly adjourn the matter for the day.
On the prayer of so and so, huh? List this matter after 3 weeks.
Is your lordship. Your lordship, regarding this, the construction, reconstruction of the existing road. Raising the level.
You see the last order, 7-1. Yes, any instruction?
I'm told that the road has already been
It's
constructed.
not a question of telling.
Lordship.
We have directed you to obtain the instruction.
Lordship, we have received our parallel instructions as well,
Ah.
and the proper written instructions will be receiving by 2, so Lordship, by 2 PM. That's why I'm praying for your Lordship. Can this matter be fixed at 2? Will be, Council B. Gogoi will address the board, Lordship, regarding this particular matter.
Lordship, my humble prayer is, if Lordship kindly permit me to withdraw this petition, Lordship.
It's better.
Yes, Lordship.
N. Alam,
Yes, Lordship.
N. Alam,
Yes, Lordship.
Mr. N. Alam. I'm not forcing, but privacy, I find that it's one of the privileged petition.
Yes,
All right.
Lordship,
Uh,
S.A. Bakhtiar, my name is.
Hmm?
My name is S.A. Bakhtiar, Lordship.
SL,
S.A. Bakhtiar.
S.A. Bhatia.
Lord.
You are for the petitioner.
Snap.
Your name is there.
Yes,
S.A. Bhatia, huh? Mr. S.A. Bhatia, learned counsel for the petitioner. Submits that he may be allowed to withdraw this writ petition. Mr. So-and-so, all of them. You are also there.
Can be one number 5 and 6.
Lordship, we record B. Gogoi's witness for
We go by
PW.
additional Berkeley.
Lordship, we record PW. Yes, PW.
CP them there are present. And the prayer for withdrawal is accepted. Accordingly, writ petition is dismissed on withdrawal.
Lordship, much obliged. Much obliged.
May I please, your lordship. Lordship, we have filed an IA for substitution of the legal heirs of the petitioner.
Yes.
He has expired on 29 September 2024, and this petition has been filed within the limitation period.
IA.
Yes, 17
IA.
Public 26.
IA.
IA.
Anybody who is appearing? Heard Mr.
BS Deccan.
Learned counsel, no objection. Learned counsel for the applicant. Writ petitioner.
Yes.
And also heard Mr. Who is 1, 2, 3?
Respondent one, Revenue Department, SC Revenue.
J. Henry. SC Revenue, huh? Standing Council Revenue and Disaster Department. And Mr. H. Sharma for State Council for respondents, huh? This is an application praying for substitution of the legal heirs of the petitioner. Petitioner has died.
Yes.
Stuff. Next para. The in the connected writ petition, huh? The WPC number 24 of 2018. The deceased petitioner led Dharinidhar Deka has filed this connected writ petition seeking direction for, praying for a direction to the respondents to disburse the land acquisition compensation. In respect of what?
His land was acquired, Lordship.
Which is the land? In respect of the land,
Measuring 7 bighas,
7 bighas,
covered by Dag number 1/51,
covered by Dag number 1.
/51.
Oblique
Patta
51.
number 1 FC grant under village Barsanda of Moza Sila Sundari Khopa of Kamrup Rural, Kamrup.
Where do you get it?
Lordship,
Final from the writ petition. You have not given in the IA.
it's in our writ petition.
Hmm.
The paragraph 3, Lordship.
Who
in our
has
writ petition.
please stuff. During the pendency, the petitioner had expired on 29/09/2025. The stuff, the applicants hearing being the legal heirs seeks to implement themselves by substituting, seeks to substitute the late Dharanidhar Deka. Stuff. Having considered that the petitioner had died during the pendency of the connected writ appeal, being WPC so and so, so and so. And the applicants appears to be the legal heirs come up, as well as, and considering that the prayer for substitution having not been opposed by the then counsel for the petitioner, I deem it appropriate to allow this application accordingly. Territory, huh? Territory, the applicants, namely so and so, 1, 2, 3, 4, 5, 6, be allowed to be completed, to be allowed to be substituted, allowed to be substituted, be allowed to substitute the deceased petitioner in the connected writ petition. I stand disposed of.
In the main case, the matter was pending for mediation. It was sent to mediation, and on several dates, mediation took place. But due to the sudden death of the petitioner, it failed, Lordship. So it may be sent back to the mediation.
You do one thing. First you have to file an amendment.
Friend has to
In
file
view
an
of the order.
amended cost item.
Ah,
Yes, I will file.
in the in view of the order passed so and so in I so and so, petitioner to file amended cost title, so and so, raised to incorporate the newly substituted petitioners. So and so, so and so. That's all. Then it will be listed again, then we'll see.
Make your orders follow.
May it please your lordship. Lordship, I want to seek an adjournment. The concern has been taken from the petitioner's side.
Joymola,
Lordship.
what is the health status?
Lordship,
It's not good, Lordship.
readings are
Lordship,
complex.
Huh?
It's fine, Lordship. We can place up-to-date report.
Who is correct?
Lordship, we have evidence, Lordship, which shows that she has been, Lordship, in any case, Lordship, the health, Lordship is a different chapter, Lordship. The first is, Lordship, she is legally confined.
No, when the health is not,
Last one decade.
no, there isn't a direction to, take care of the health. If the health is not good, what's the question of bringing it back?
Occasion they make the submission, the health is not good, the health is not good. We have been placing up-to-date quarterly reports of the health of the.
So place some videos, Lordship, where she has been. she has
They already-
With some rocks and all, Lordship.
They make it, your Lordship, every time, but they have not bring in anything on record till date.
Lordship, we can bring it on record, Lordship.
Let them bring it on record, Your
We have
Lordship, we'll
video-
produce.
Video evidence there, Lordship.
We have the up-to-date medical health report.
You are for,
I'm for the state of Tamil Nadu, Your Lordship.
then,
I am for the, Lordship, pressman number 8, that is PETA, Your Lordship.
huh?
It's an NGO, Your Lordship. Because of our
Peter, huh?
presentation, Lordship, these things came up as highlight, Your Lordship.
Earlier also, Lordship, they have placed one news item before the court, but when the court asked to bring that on record, they have not brought it, so till now.
We can bring it on record, Lordship.
Anyway, we're adjourning it.
Okay, but we
Any
are-
objection?
For
Who is seeking adjournment?
Lordship,
Huh?
respondent 11, Lordship.
Who is responding 11?
Temple, the temple.
Hmm?
For
The
the
temple, yeah.
temple.
Temple, where it was taken?
Lordship.
Where Joymala was taken?
If the lordship is pleased, I want to take time in the month of, any time in the month of March, first week.
Lordship,
March. You agreed that, I
Lordship,
don't know.
Lordship, it has been, Lordship, again and again, adjournments has been taken, Your Lordship.
They have filed the reply.
I think March is, Lordship, is too much, Your Lordship, for me.
It's not your petition.
March, actually, lordship,
It's not my petition, Lordship, but I'm concerned.
It's
about
filed by
the-
the state.
Yes,
also it's concerned the state.
Where you were?
That I appreciate, Your Lordship, but because of our representation, Lordship, these things came up on light.
On every occasion, they
Yeah,
make
the
this comment, Your
difficulty
Lordship,
is
but
what-
they never bring anything on
I
record.
think, I don't know, but then, I just want,
Oh, affidavits, Your Lordship, that's it, there are affidavits filed by the Rasman number 8, Your Lord.
where is AG?
There are pictures of.
Where is Advocate General?
lordship, AG is in some other court, appearing in another court, lordship.
Prayer for
They had
adjournment
You
was
are,
made, Your
you are
Lordship.
appearing on behalf of?
Me, Your Lordship, I'm for the state of Tamil.
Who is leading, who is your leading counsel? In fact, the maintainability, of course, the learned AG on the first day has placed some judgment.
Lordship.
I'm not that convinced. Today, I thought this will be heard.
Yes.
They have
Although,
come to the-
although it's not a dispute between the state,
Ah.
between the state, one state to another, or the dispute between center and the state, strictly 131, Article 131 may not be applicable. But then do we have a jurisdiction, this High Court, over the other state, where they have their own, High Court or whatever, having the jurisdiction? This is something, before we go into the merit.
That's-
We will make submissions of
I've
that.
seen it, learned AG has placed two judgment of the Supreme Court
Lordship,
on the first day.
For, Honorable, Tripura High Court, Lordship.
Yes.
And in those cases, Lordship, reference were given to the file, Your Lordship.
Ah.
Those cases were sent to HPC, Your Lordship. That's a high power committee considered by the Tripura High Court and thereafter by the Supreme Court.
They regarding the jurisdiction.
No,
The- No, I am on jurisdiction. See,
It has to be decided, Your Lords. Yeah,
this
again.
High Court has the jurisdiction of only 4 states, right? And if any direction has to be passed, we have to pass the direction to the state of Tamil Nadu. All right,
Yes, Your Lordship.
so that I have some reservation.
The state is insisting, I believe, but I think it is
Lordship,
not
we will make
available.
submissions on the maintainability as well as jurisdiction, Lordship, when the matter will be heard, Lordship.
Anyway. MS
Dr. Leakits.
Learned Council for respondent number, your name is there.
Lordship,
Respondent number 11. On the consent of the Learned Council for the petitioner as well as other response. Press for listing of the matter after 4 weeks, we'll say 4 weeks.
Lordship, actually, the final argument will be led by my senior counsel from Delhi.
Whatever.
Final, so.
You have to
in
arrange,
February,
cannot.
his daughter-
Four
his daugh-
weeks is, it's enough, 4 weeks.
March any day,
Well, if
Lordship.
that fix that,
Lordship.
then therefore we'll make it 4 weeks.
Lordship, because his daughter's marriage is fixed in February and he wouldn't be here, here physically if it's in February, so. March, first week of March.
4 weeks. MS
Lordship, P. Borua.
P. Barua, Learned Council for the petitioner.
It's February, then again, he won't be able to
Mama,
come. and have this.
Mr. So and so, record all their name. Correspondent number?
Your Lordship.
Huh?
AR Gogoi for 226.
426.
226.
226.
DK does for number 8.
Huh. Who is for one?
One is-
You would have been here.
Anyway, are present. Are present, huh? Prayer is allowed, list after 4 weeks. You agree that date, whatever.
March first week, anytime. Lordship.
On February.
Let it be on February, then
No,
again.
it's of no use pending, I mean, listing it again and again.
If
We'll
my,
finally dispose of, make
Fix
it
on-
in the first week of March. As agreed to by parties, Learned Council by parties, list this matter on 5th March. Definitely. Madam, you come prepared, you tell your senior. Although we are not recording,
yes, on
we
first March,
may-
he will come physically.
we'll
he will
take it up for disposal.
Observe that the endeavor should be made also to.
It's okay.
oblige your Lordship.
May I please your question?
Lordship, this matter, I apologize, Your Lordship, I'm still awaiting my instructions. This is regarding claims.
You
extension
said-
Claims for.
No,
train
no, you said
accident.
the notification doesn't
Yes.
cover.
Notification is.
The
covered.
case of the petition doesn't cover.
That instruction I'm awaiting, Your Lordship. This
No,
is a
you
claim-
have submitted
Lordship,
content 11.
yes, Lordship. As per the notification, your
You
Lordship.
said submits that the N. Bordolel and so and so.
Your Lordship, yes, yes. Your
Petitioner is, the claim of the petition is not covered by the government of Assam noted in 15/11/24/14. And she would like to file an affidavit. Please.
The department has written to the Deputy Commissioner, Your Lordship, for the details.
Madam, why you have said that it doesn't cover? Let us see the notification. Where is the
At
notice?
page 25, your Lordship.
Page 25.
Serial number 3. Sorry, Lordship, 24, at page 24. Serial number 3.
Exgressor, no person killed due to accident in public places or public areas other than killed by extremists as also and so.
And I have annexed an order passed by my Lord Justice Zaitun Thambai, annexer 8, your Lordship. Similar situated matter. At page 26, I start, and operative part at page 29, paragraph number 10, Your Lordship.
Lordship, if
Where is your, this thing,
Jorhat, Your Lordship.
medical?
Medical report. Medical report, Your Lordship, postmortem report at page 14. Type copy, Your Lordship.
Page,
14. Annexure 1. Cause of death mentioned below down, Your Lordship. That was police report at page 18. Police report also there at page 18 and etc.
It says that unknown person.
Yes, but unknown passenger.
So how do we, have you, well, any application
No,
before
no.
the deputy
He is
commissioner?
not bona fide passenger. So,
Hmm?
This was not bona fide passenger, therefore his application not applicable before
didn't
the
the ticket, Your
railway
Lordship.
tribunal, Your Lordship.
Hmm?
Not as he's saying, he's not a bona fide passenger.
Yes, Lord.
He didn't have the ticket,
Therefore,
I
his
guess.
claim is not maintainable before the railway tribunal.
No, who has to pay? Deputy commissioner?
Deputy commissioner.
Have you applied
Yes, Lordship.
under this?
At page Lordship 22 and 23.
Anyway, you file your affidavit.
Lordship, I have a coordinate benches order, if Your Lordship would please.
Same thing, they have also annexed.
He has annexed a different case, Your Lordship.
No, will you file the affidavit?
Which one?
You said that it's not applicable, right?
Should the public place is well defined in the.
Public place or in public area.
Yeah, yeah.
So here in the notification in serial number clearly mentioned public. place
Third,
and public-
Mr. So-and-so, learned counsel for the petitioner. MSN Bordele. Submits, learned standing counsel revenue and disaster management department. Press for and is granted further 2 weeks time to file affidavit. As the as she makes a submission. As she submitted that the claim of the petitioner is not covered by the government notification dated 15/11/2024. Huh? List after 2 weeks,
Yes.
you file an affidavit. Keep
So-
it yourself. You place on that day.
As what, so Monisha, no?
Oh,
You just share him, you share the copy of this judgment. Give a return it.
Okay, I need a 2 weeks time to file additional affidavit, Lordship.
What's there? Nothing.
Lordship,
See, it's a political rivalry.
not actually, Lordship, so
You are AGP.
ACP, Lordship.
These political battles should be fought outside the court.
No, there is a political, sorry, police atrocities are also there, Lordship. Police atrocities also there, Lordship.
You said
Back of the,
I mean,
all
of the-
except
of the-
Lordship,
of the record,
Lordship.
are you not the alliance of the,
Yes, Lord.
You said so.
Alliance is there, Lord.
Then
No, Lordship,
it's
that's fine, Lord.
purely a political thing. Maybe there may be a threat and other thing. Why don't you fight it out?
Lordship, I have to file.
That too, you are in the same, you are alliance party.
Alliance party, Lordship.
Then
Yes, but Lordship, atrocities is there, Lordship.
how do we do? It's a purely political. Fight it out there in the field.
List of the record, Lordship, but in reality, that is Lordship, some
This court is not convinced.
Lordship, 2 weeks, Lordship.
It's a fight between you, respondent number 7, 6,
Eight.
8.
Local MLA.
He is BJP,
He is BJP.
BJP
but,
MLA.
Politically not.
You
the
are
party.
your
AGP, Lordship.
AGP.
Lordship.
You are allies. Fight it out there. We'll be dismissing it.
Lordship, 2 weeks, Lordship, I'll file some.
What more?
Lordship, yes, Lordship, I have some certain the photographs also, Lordship. I have to show Lordship some high-handness of local MLA, Lordship. That's why the police is not
Which for the police department? Have you registered the case? Any investigation?
Only one case has been registered, Lordship. Other
What more? One?
registered, Lordship.
What is the status of investigation? What is the status of the case?
He produced para 4 members. Para 4 of
Just
that.
tell us.
Upon ZD entry 664 on dated 26/5/2024, Lumding PS number 131/2023 under section 120 B 448 427 494 506 IPC was registered on 9/6/2023, and upon completion of the investigation of the case, charge sheet the case was charge sheeted by charge sheet number 125/23 dated 30/6/2023 under the said sections, my lord. On
Who are
twen-
the accused?
On 29/5/2003, one complaint email was received with subject line FIR Old AGP Office Lumding so and so. The complaint was inquired into and it revealed that allegedly one Ajay Day was illegally occupying the premises of one Sri Subrata Das. It revealed that the matter was pertaining to non-payment of rent of old AGP office and no cognizable offense was made out, and hence Lumding PS non-FIR case number 29/2023 under section 107 CRPC was registered and sent to DC office Hosai for further action. On 35/2023, one email complaint was received regarding removal of AGP party board from the old AGP office, etc. The matter was inquired into by Lumding PSK ZD number 727 dated 35/2023, and it was found that no cognizable offense was made out. On 5/6/2023, an email was received by the Superintendent of Police Hosai mentioning inter alia that the complainant Sri Montos Paul is under scrutiny, security threat, and fears that some miscreants may attack him. It also mentioned that there have been instances of locking out and computing of old and new AGP offices. The matter was inquired into and it was revealed after inquiry that petitioner and his family members do not have any kind of security threat. Regarding the complaints of occupation and locking out of old and new AGP offices, both the matters had been inquired into and no cognizable offense had been made out in either of the cases. In this instance, after inquiry regarding dispute of land ownership, where the new AGP office is located between Srimati Tina Chaudhary, wife of Jayanta Chaudhary of Officer Colony, PS Lumding, District Hosai, Assam, and Montos Paul, son of late Bhupen Chandra Pallab, Misripatti PS Lamding, Assam Lamding PS, non-FIR case number 25, 2023, under section 107, 145 CRPC dated 27/5/2023 was registered. After inquiry regarding locking out of old AGP office located on the land of Sri Subrata Das Lamding PS, non-FIR case number 2923, under section 107 CRPC dated 16/6/2023 was registered. With regard to the statements made in paragraph 8, read petition respectfully state that an email complaint addressed to officer in charge Lamding dated 8/6/2023 was received with subject FIR. The earlier things are reiterated, my lord.
Ah.
The complaint
Okay.
date, details of complaints sent to 15/5/2023, 21/5/23, 26/5/23, 27/5/23, 28/5/23, 29/5/23, and 30/5/23 were mentioned. All these complaints were registered and action was taken. The action taken on the complaints is under the para 5 that we have what action has been taken. It is particularly mentioned.
One matter, charge sheet has been filed.
Charge sheet has been filed.
First FIR.
And others
Then
are
what more you
non-cognizable
want?
offenses, my lord. And space 16, para 5 last, we have mentioned.
Purely out and out political rivalry. Your FIR has been taken, registered.
Only one.
All some other cases, some other FIRs, it doesn't disclose any cognizable offense. It has been investigated, inquired into. Accordingly, action has been taken in accordance with the law. And one FIR, after the investigation, charge sheet has been filed. Then, how do we interfere? We thought at best this thing FIR might not have been taken into account and no investigation, no inquiry has been caused.
Madam.
In any case, Lordship, I have to file, Lordship,
What?
some photographs also I have.
What
Lordship,
photograph?
That,
Then you file before if there no I mean according to you if the police has not taken in accordance with law, you approach the magistrate, concerned magistrate.
how they look.
It's the law.
The only one week, Lordship.
Hmm?
1 week, Lordship.
What 1 week? For what?
For respond the affidavit filed by the MLA Lordship and additional some digital documents, Lordship.
We're not concerned about the response of the MLA. There will be never ending between you and the MLA.
Otherwise, Lordship, we are.
Even within the alliance, you want to, have the more power. Obviously, it is understood. Yes.
I simply deny the all fact because they are presumed.
Who are you?
I am for the MLA. MLA.
You act like an MLA.
Yes.
He's your alliance partner.
Yes, there is
He's your
nothing
partner.
like that.
Anyway, we're not going to hear you. We're not convinced the writ petition is maintainable.
1 week time, Lordship.
I'll record it. Privacy writ petition is not maintainable.
Up to your Lordship, Lordship.
Anyway, 1 week, we're granting him 1 week. Think about it.
Lordship.
Political fight, not here.
Otherwise, we are in
You
alliance.
fight
Lordship.
there in the field. It's a game of what do we call convenience. Fight out there in a field where you have to fight, not here. All right. Only to take instruction, we're not going to hear you. I have seen your papers, everything. Nothing. Out and out political issue, fight it out. And the police has taken actions. They've done their job in accordance with the law. If you are agreed, you approach the appropriate forum.
Also might have repeated. We have any kind of a grievance, anyone against.
That is what I'm trying to indicate. We're
Morning.
adjourning it for 1 week
Morning.
for withdrawal of the writ petition or dismissal. On the prayer of Mr.
D Dole, Lordship.
D.
Dole.
Dole, learned counsel for the petitioner. That this matter be listed after 1 week so as to enable the learned counsel for the petitioner, so as to enable him to obtain instruction as regards the continuation of these proceedings in view of the fact that prima facie no case is made out for excesses of writ jurisdiction in these proceedings. All right.
Item 8.
May it please the Lord.
Yes.
My Lord, the matter otherwise ready for final disposal, I hope I can press it on merit. Ready for disposal. My Lord, in a nutshell, facts are like this. I'm a
Are you
co-
ready?
We have filed a affidavit, we have stated everything, right? My Lord, I am a cooperative society. I entered into a contract of carrying and delivering the food grains from the FCI godown to the another cooperative society. And there was an agreement with me.
All the parties, just wait, sir. All the parties are represented. It's only for the deputy director, deputy commissioner,
Deputy
director,
Director, all government, yes,
all government, yes,
all government.
yes, yes.
Now, there, on the basis of that agreement, I started working. The contract is to be performed in two steps. One tier is that first carrying the food grains, food items from the FCI godown and delivering it to the GPSs. And then from GPSs to fair price shop.
What is GPSs?
Well, GPSs, Gaon Panchayat Samabay Samiti Limited,
Go down.
that go down. In every Gaon Panchayat, there is a Samabay Samiti. And they, within
And
their,
WCCS,
sorry,
WCCS,
WCCS is Wholesale Consumer Cooperative Society.
Wholesale Consumer Cooperative Society, and Gaon Panchayat,
Samabay Samiti.
Gaon Panchayat,
Samabay Samiti.
Samabay Sam.
Cooperative Society.
Okay. Samabay, same.
Samabay, same. One is Wholesale Consumer Cooperative Society. And the other is Gaon Panchayat Samabay Samiti. I am to deliver it to the Gaon Panchayat Samabay Samiti.
What is Samabay
Samabay means cooperative,
cooperative?
cooperative society. Now, I am to perform in two steps. First, I am to carry the food grains from the FCI godown when it is allotted to me as a carrier, transporter. And then I am to deliver it to the godown of the GPS, Gaon Panchayat Cooperative Society. That is the first tier. Second tier, the Gaon Panchayat GPSs, that is Gaon Panchayat Cooperative Society or Samabay Samiti, they make allotment to their respective GP, the fair price shops. There are fair price shops within their jurisdiction in every panchayat. When they make such allotment and they give me the list of the allotment order, ask me, I deliver it to the doorstep of those fair price shops. That is the second tier. Now,
Agreement of theirs.
kindly come to page number 30, annexure 2. It will make this, that agreement was executed between me and the deputy commissioner. This tender agreement, office of the deputy commissioner, Dibrugarh, Lordship at page 30, annexure 2. Agreement for transportation of allotted food grains under National Food Security Act for Dibrugarh district by appointed transport contractor Messrs. Larua GPSS, that is Gaon Panchayat Samabay Samiti, Gaon Panchayat Cooperative Society, that is. This is the petitioner. I am Messrs. Larua, Gaon Panchayat Samabay Samiti. This agreement is made between the Deputy Commissioner Dibrugarh and as first party and Messrs. Larua GPSS as second party. Duly executed on this 9th day of February 2018 at 11 AM in the office of the Deputy Commissioner Dibrugarh. Whereas the Food, Civil Supplies and Consumer Affairs Department is implementing the National Food Security Act, hereinafter called the NFSA, in Dibrugarh district and required to transport allotted food grains under NFSA from FSDs of FCI, food storage godowns, my lord, these FSDs, depot, to of FCI, Dibrugarh, Goshala, Shoki, Saul Khwap, FSDS, in the Dibrugarh, to the Gaon Panchayat Samabay Samiti, hereinafter called the GPSS, for ultimate delivery to the doorsteps fair price shop
This was
located.
of 9th February in 2018.
My lord,
9 February 2018.
yes, yes.
Okay, no issue, no dispute,
No,
no dispute,
so far this is concerned, no.
no dispute.
Now here, kindly mark few terms and conditions. Page 30. Whereas the transporter, Mrs. Larua GPSS shall perform the transportation work of food grains in 2 tiers. This is
No dispute.
tier 1 from SFD of FCI, Dibrugarh, to the godowns of GPSS under Borborua Development Block and Jaipur Development Block. This is the first tier. Tier 2, from GPSS godowns to the doorsteps of FP shops, the fair price shops. As the so and so. Rate per quintal, they have given this rate, all these are there, there is no dispute. Then kindly come to 3. The transporters, Larua so and so shall keep with the Deputy Commissioner Dibrugarh a sum of rupees 10
Is that-
lakhs only as interest-free security deposit, that is there. Then 4, the term and condition mentioned in the letter tender notice shall prevail for the transporter contract given so and so, valid till 31 day March 2018. Payment of transport charge shall be paid to the transporter contractor, submission of bills on successful completion.
It's
6,
valid up to 31st day of March 2018.
18. The transport contractor shall deliver the allotted food grains transported by them to the nominee GPSF, WCCS in tier 1 and to the FS shops dealers tier 2 properly without any loss, damage.
Sir, this is valid up to 2018,
Yes,
31st March.
yes.
So you said that you have carried out in 2023.
This was continued. This was
Yes.
continued as such. So this same terms and conditions, this,
Where does it say that unless it is rescinded or revoked, it will continue? Is there any provision? I mean, the condition,
Uh,
there's nothing.
there is nothing. There is nothing. This was signed in 2018,
Valid up to 31st March
31st March, but this,
2018.
this contract continued. This was operating. This was
How do you know?
This
How,
was,
how do we know?
well, let the department say if your lordship feels.
No, that's
because-
why since you are reading, it has to be some relevance.
Well, because,
Relevancy is two tier. Number two, valid up to 31st March 2018.
because why I am submitting, on the basis of this, I was allowed to carry, transport and deliver. This contract was going on. It was continued.
That's why, sir, I'm asking precisely.
There
Where
was
does
no,
it say? Since you are reading it, where does it say until it is
that
rescinded
is-
or revoked?
that
It
is
will
not there.
continue.
That
There
is
is
of course-
nothing.
That is nothing.
So
There
there's
is
no
nothing,
dispute.
but they impliedly,
Ah,
not expressly,
ah.
they continue. With the same terms and conditions. Same terms and conditions.
Yes, then
Uh,
January 2018, nothing.
Yes, here, 9, Lordship may see, the transporter shall adhere to the lifting program of food grains provided to them by the authority FCI and shall be bound to complete delivery of allotted food grains to the nominees in time and within validity period. The transporter shall be responsible for any loss, damage, leakage, theft, replacement which inferior quality of the transported food grain and shall have to compensate for any such irregularities besides liable to face prosecution. Now, under these terms and conditions, I was performing my duty and it was going ahead and continued. Thereafter, what happened, my lord? In March
You have continued up to 2023
2023.
for one tire.
No, for both the tiers. There was a
Contract
dispute.
is for both the tiers.
Two
He has
tier.
to leave from godown and deliver it to the GPSs. Then in second tier, the same thing he has to deliver to
To
the
the
retailer.
GPSs. The fair price shops.
But
This was being done. And they detected that in the month of May and June, there was some foul play in the office of the GPSs. And they issued a notice to me. Lordship will kindly come to that notice at page 11, page 71, annexer 11. Annexer 11, page 71. This is dated May 24, 23rd May 24, 21st May 24, 23 and 24, 23. Lordship got it, my lord. It was addressed to Messrs. Larua Sawabai Samiti Limited. So cause notice. Kamrup PS case number so and so. They have referred to, there is a PS case number. Whereas, I'm reading, madam. Whereas the inquiry conducted by a team of FCS and CA officers, Dibrugarh, at Messrs. Namrup GPSs Limited. This is the society to whom I am to deliver. Namrup. It is detected that secretary and officer and other office bearers of the GPSs are involved in malpractices and diversion of highly subsidized TPDS rice under NFSA 2013. As per the provisions of serial number 6 of tender agreement dated 9/2/2018, executed by your firm, the transporter contractor shall deliver the allotted food grains transported by them to the nominee GPSs and WCCS in tier 1 and to the fair price shops dealer in tier 2 properly without any loss, damage, shortage, etc. of its quality and quantity. On the other hand, as per the provisions of serial number 10 of the tender agreement, the transporter shall be responsible for any loss, damage, leakage, theft, replacement with inferior quality of the transported food grains and shall have to compensate for any such irregularities besides liable to face prosecution as per provisions of law. Whereas Mrs. Namrup GPSS has not distributed TPDS rice to the FPS dealers for onward distribution to the beneficiaries within the government stipulated time frame, that is 15/5/23 to May 2023 quota. And June 2023 quota till 15/5/2023, date of inquiry. The whole allotted quantity is believed to be diverted into open market in league with the office bearers of Messrs. Namrup GPSs to garner undue illegal profit. So this is Namrup GPSs where I am to deliver. I have done it. Being the transporter of Messrs. Namrup GPSs.
Yes, being the transporter.
Yeah, being the transporter of.
You are the
Messrs.
transporter for MS number of GPSs.
I am to, that means I am to carry and deliver it to the Namrup GPSs. They are the authority to receive it. I carry for them and they distribute it to the fair price shops. When they ask me, I deliver to them. You are liable to supply the food grains to the GPSs as well as the doorstep of fair price shops, dealers under the GPSs. You are found to have lifted and transported the allotted 1081.80 quintals of rice for May 2023 during the period 18/3/23 to 23/3/23 and 1082.50 quintals of rice for the month of June 2023. Lifted and transported in the month of April 2023 from FCI, Saulkhwa, FSD. The non-distribution of the said allotted quantity to the concerned fair price shop dealers in time indicates that you, in league with the GPSs, has diverted the TPDS rice under NFSA 2013 for illegal personal gain. This is what they want to say against me. I'm repeating this line. The non-distribution of the said allotted quantity to the concerned fair price shop dealers in time indicates that you, in league with the GPSs, has diverted the TPDS rice under National Food Security Act 2013 for illegal personal gain. The above acts are clear exhibit of contravention of terms and conditions of tender agreement dated 9/2/2018 and the terms and conditions of NIT so-and-so dated 18/2/2016. Therefore, you are asked to show cause as to why NFSA transport contract shall not be terminated and why the value of 2160.30, that is 2146 for print 30 quintals of delivered food grains, TDPS under so-and-so shall be realized from you. 2164.30, that is they want to deliver. Your written reply must reach the office of the undersigned within 7 days from the date of otherwise termination of SS transport contract and forfeiting the security money legal action will be initiated. Now, here Lordship will kindly see, in this notice itself, they have said that I have carried it and delivered to them. Delivered to them, this Namrup Cooperative Society. But there is no further distribution from the GPSS to the fair price shops dealers at their doorstep. They doubt that I am in league with them, diverted. Then I have shown a reply. I have given reply. And I have very categorically said, giving the details of everything. Lordship will see at page 72, my lord. My reply, 29/5/23. Third para. We have not violated the provisions of serial number 6 and 10 of the tender agreement dated so and so, and terms and condition of NIT so and so. And a reply to the so-called is stated below for favor of your wise judgment and kind consideration. For lifting of rice in tier 1, the secretary of any other authorized person needs to endorse their lifting book in your office, and thereafter the release order is issued by the Food Corporation of India. The said release order is sent to the FCI FSD for lifting of rice, where the secretary chairman by himself or their representative have to present and acknowledge the receipt of rice in the depot. We are not authorized to acknowledge the receipt of rice in the depot. We as a transporter place the required trucks and issue road challan only for transportation of rice to the concerned GPSS godown. After unloading of the illegal lifting quantity of rice at GPSS godown, the secretary or any other authorized representatives acknowledge the receipt. So they receive it. I place the trucks, issue the road permit, and they receive, the GPSS receives it in their godown, they issue the challan. That yes, these are received. This is my duty. For distribution of rice in tier 2.
Come to page 76. Let's see read the impugn order. I've
Yes.
read your reply.
Lordship has
I've
done
read
so.
your reply.
Yes. When I have given in details that there was no foul play on my part. Now come to page 76. Peruse the inquiry report relating to inquiry conducted by Messrs. Namrup GPSS submitted by Sri So-and-so, Inspector Dibrugarh, along with FIR submitted at Namrup Police Station, Dibrugarh. It transpires from the case records that the secretary and other office bearers of GPSS are involved in malpractices and diversion of highly subsidized TPDS rice under NFSA 2013 in league with NFSA transport contractor. Also peruse the NIT number so-and-so and the tender agreement dated 9/2/2018 made with Messrs. Larua GPSS along with so-called notice served to so-and-so. So-and-so Messrs. Larua GPSS who has entrusted the transporting NFSA 2013 rice to Messrs. Namrup GPSS in both tier 1 and tier 2.
Para 3. Let's read para 3.
Now, during personal hearing undertaken on 22/6/2023, Sri Gokul Das, Secretary of Messrs. Larua GPSS, petitioner, had failed to substantiate the charges about their involvement in diversion of government highly subsidized NFSA 2013 rice in league with the office bearers of Messrs. Namrup Sambai Samiti Limited. Here, well, they have put the onus on me that I am to substantiate the charges. The language Lordship has marked. They have put the onus on me. They say the Larua GPSS Limited has failed to substantiate the charges about their involvement in diversion of government highly subsidized so-and-so in league with the office bearers of so-and-so. The transporter also failed to submit the delivery receipt from the FSP, Fair Price Shop dealers, regarding successful delivery of transported food grains duly signed by the recipients and counter signature of the Secretary of Messrs. Namrup GPSS, as per point number 7 of transport agreement. While the transporter was questioned about effecting Tier 1 delivery of June 2023 quota without completion of Tier 2 delivery against May 2023 quota, which attracts violation of point 7 of transport agreement, and about non-providing any information of the FCS and CA branch or district authority regarding non-completion of May 2023 quota in Tier 2. No explanation could be provided by the NFSA transporter. This is incorrect because I have given in my reply that for Tier 2, no allotment was made to me. They have said that yes, Tier 1 was complete, but Tier 2 was not done. For that, they will have to make allotment to me. Otherwise, how can I on my own deliver it? No. That is what my case is. They have not considered it. They say they could not, could be completed. No explanation could be provided by the NFSA transporter. This is not correct. On the other hand, in notarized undertaking number so-and-so dated 19/6/2020 submitted by Sri Gokul Das, Secretary so-and-so, Larua, submitted during the personal hearing, his writing accepted that they are duty bound to shoulder the liability and responsibility of the alleged diverted rice subject to outcome of Namrup PS case number so-and-so. Yes, if it is proved that there was diversion, then I am liable, but otherwise this was not. Further, it transpires from the records that as per the provision of point number 6 of tender agreement dated 9/2/2018, executed between the transport contractor and the district administration, the transport contractor shall deliver the allotted food grains transported by them to the nominee GPSs and WCCS in Tier 1 and to the FP shop dealers in Tier 2 properly without any loss, damage, shortage, etc., quality or quantity. On the other hand, as per the provisions of serial number 10, the tender agreement, the transporter shall be responsible for any loss, damage, leakage, theft, replacement with inferior quality of the transported food grains and shall have to compensate for any such irregularities besides liable to face prosecution as per provisions of law. Whereas Messrs. Namrup GPSS has not distributed TPDS rice to the FSP. Now, this is Fair Price Shops dealers for onward distribution to the beneficiaries within the government stipulated time frame, that is 15/5/2023 for May 23 quota and June 2023 quota till 15/5/2023. A part of May 23 quota and the whole allotted quantity for June 2023 quota is believed to be diverted into open market by the transporter Mrs. Larua in league.
So you are
with the
found to be involved and you have violated the terms and condition. Therefore, your contract is terminated and your
forfeited.
security deposit has been
Is forfeited.
forfeited.
Yes,
That's
this
all.
is now on the face of it, Lordship will find that these findings recorded are unfounded, illegal. Terms and conditions say that I am to perform the duties whenever allotment is made to me. They have admitted, yes, you have for both the months, you have delivered the first year. You have taken it from the godown of the FCI and delivered it to the Namrup, godown of the Namrup GPSS. But the second tier was not performed. Second tier was not performed.
Failed to submit the delivery receipt from the fair price of dealers regarding successful delivery of
Yes,
transported
yes,
food grants duly signed by the recipients and countersigned of Secretary of Namrup.
yes. Before that, my lord,
That
they
you
are-
have admitted in
Well,
your reply.
No, no, what we have said that they have not allotted us for delivery to the GPSs, that is fair price shops.
See,
it is
page 74, serial number 6. Further, due to non-issue of memos and distribution of the rice in Tier 2,
Yes,
Tier 2 by the Namrup J, we have not been able to submit the transportation bills for the month of so and so.
yes. Since they have not allotted us, we could not deliver it, we could not submit the bills also. It is the GPSs who will have to, because.
No, you have to.
Hello?
You have to submit this receipt and countersigned
No,
by
my
the
lord,
secretary of
yes,
the Namrup.
But there is a second part. First part, they will have to allot us. They will have to intimate me that you deliver these items to such and such fair price shops. This is the duty of the GPS.
No, wait, the question of not allotment. When you say that they have not given you memos,
Yes, they will have to give me memo allotting.
no, see,
Untu puise?
serial number 6, page 74. Due to non-issue of memos and distribution of the rice in two-tier by the Namrup, we are not able to submit the
Yes.
transportation bills.
Non-issue of memos and the distribution of the rice in tier 2 by the Namrup GPSs. We are not been able to submit the transportation bills for the month of April 2020, May
Yes,
2026.
what does it mean?
Therefore, first thing, my lord, first thing, they will have to show that you got this as in the first year, they will have to show that you got it from the go down of the.
That's why initially I asked
No.
you whether you have performed only one tier or two tier.
The second tier, first tier is complete. So similarly, second tier, the GPSs, who is the authority, number of GPSs, will have to allot it with the list of the beneficiaries to me.
So according to you, you have not performed that.
No, because they have not given it to me. They have not allotted to me. I could not.
That's
perform.
why at the outset I asked you whether you have performed that one tier first, one tier or two to both the tiers.
One
tiers.
tier. But we could not.
You
If
said
for,
two tiers.
no, for the other month, previous months, it was done in that way. Regarding these 2 months, we could not. All throughout it was regularly done.
And in that case, why have you not directly said that I have not performed the two tier?
2 tier in the,
You said non-issuance of the memos and distribution of rice. You could not submit the transportation bills.
well, that is to indicate that had I been done, had the duties been done, I would have submitted the bills also.
Sir,
I
if
could
I
not.
correctly understood the English language, this is very clear. There's no ambiguity.
No, my lord. True.
You are trying to say in clear, meaning, in literal meaning, that since the Kamrup secretary has not issued the memos and distribution of rice, I could not, submit the transportation bill.
Transportation bill, I could not perform my duty. That's
No,
why I
no,
could
no,
not
no, it doesn't say. Please read it.
My lord,
Serial
Lordship,
number
no,
6.
this is regarding that particular statement regarding the submission of bill. Now,
This is very
kindly
crucial.
also see,
This language and the serial number 6 is very crucial.
my lord, kindly see.
When you say
Carry-
that you have not performed.
No, my lord. I can very well understand the lordship's anxiety. So far, this.
No, it's not my anxiety. I say only I'm on the plain and simple meaning of
true.
your reply.
True, my lord, lordship.
Your
will-
reply in the sense,
Yes, sir.
petitioner's reply.
My lord, that is, of course, lordship will see as a whole. Particular statement of going there by these people.
You know us anything that you have not performed.
Yes, my lord, here see,
Second tier.
let me read it from page 72, my lord. As a
Page
whole,
70.
let us consider what they have said, what is their contention. From,
No, sir.
from,
Please show me a relevant para. I show you this relevant according to
Well,
me.
true.
The relevant is
But
serial
I will-
number 6.
I will request your lordship also to read the previous paragraphs so that we can.
No, issue I am.
Get a-
You see, I have seen everything. I have read it. But the point which you are trying to say, I mean raise, is that you have not performed the second tier. Second tier. Because you have not been given the work, is not it? That you just show anywhere.
Have
I
not
mean,
been-
in any
Yes.
sentence you have said so.
Let us see, my lord. That is what I am saying. That
Yes.
is what I want to go to your lordship.
Sir, if you started reading all of these 4 pages, 5 pages, days will be finished.
Don't. For distribution
They will
of
be
tier
finished.
2,
Ah.
I am reading at page 72, second paragraph.
Said.
Hmm.
and the
I'm
department did not issue highest dealer.
Yes, I will come in. I will come in. Kindly see, my lord, from paragraph 2 of page 72. The distribution of rice in tier 2, it is the responsibility of the secretary chairman of the GPSS to issue memos to the FP shops under their jurisdiction and give demand to us. Give demand to us for placing the required vehicle for transportation of rice to FPS. This is first requirement they will have to perform. We place vehicle as per the memos and demand received from the secretary and transport the allotted rice to the concerned FPS, fair price shops, as per norms of the tender. In the case of Namrup GPSF, we have transported so and so quintals of rice against May, so and so quintals of against month June 23 quota during the month of so and so, and unloaded in the Namrup GPS's godown. The same have been duly received in full quantities and in good conditions by the secretary or authorized representatives of Namrup so and so. Receipt copies are enclosed herewith for your ready reference. These are details of the trucks, transported quantities. We have given the details. These are there. And then say, sir, you know that the government had instructed to lift the transported the rice against so and so, and so and so quota in very short span of time, for which we were very much involved in completing the instructions from your office to avoid lapse of the allotted quantities. In the meantime, we were in continuous contact with the Secretary of Namrup GPSS to issue us with programs and memos, since we are not authorized to issue memos and transport the rice to the FPS without memos.
Please.
So
Huh.
that we can place our vehicles to
Pla-
complete the delivery of so and so.
Para 4. Serial
Para
number
4.
4.
Para
Serial-
4.
are you reading serial number 4?
Yes, yes.
Huh.
Yes. So, Lordship will see, here, in the meantime, but because there is a time schedule, we are in direct contact with the department that they are not doing it. Give me
Read
instructions.
it, read it. Read the whole.
Sir, as you know, that the government had instructed to lift and transport the rice against April 23, May 23, and June 23 quota in a very short span of time, for which we were very much involved in completing the instructions from your office to avoid lapse of the allotted quantities. In the meantime, we were in continuous contact with the Secretary of Namrup GPSS to issue us with programs and memos. Since we are not authorized to issue memos and transport the rice to the fair price shops without memos, so that we can place our vehicles to complete the delivery at fair price shops level tier 2. But the Secretary of the Namrup GPSS did not turn up our request, nor they informed your good office about non-issue of memos and stock of for the month of May 2023 and June 23. The Secretary of the Namrup GPS had been doing the same in the past as well. But with our continuous pressure, he ultimately issued the memos and we carry out our work. Considering the past action of the Secretary of Namrup GPSS, we did not file complaint. But this time, he kept us in dark and we were totally unaware of the unethical motive and action that he has taken. Regarding loss, damage, shortage, etc. of the transported rice during tier 1 and tier 2 and compensation of the same, by the transporter as per the provisions of serial number 6 and 10 of the tender agreement, I would like to inform you that no quantity of rice against May 23, June 23 quota had been lost or damaged during the time of transportation. The same had been unloaded in the GPS's godown and acknowledged and received in full quantities by the Secretary of the
No,
Naval
it's okay.
GPS.
We haven't understood.
Then
one-
further he says then,
No, no,
due
no.
to
no, no,
non-issue
before
of
we-
some
Sir,
memos.
just a minute. Sir, just a minute,
Yes.
please.
Mal.
Read the 10th line of para 4, serial number 4. The Secretary of the Namrup GPSS.
Yes, had been doing the same in the past as well.
Hmm.
He earlier also he did like this. But with our continuous pressure, he ultimately issued the memos
And when
in past and we carry out our work. Well, it is referring to the past conduct.
no, no, he said Secretary of G had been doing the same in the past as well.
Yes,
But with our, this comma
Okay.
is there, but with our continuous pressure, he ultimately issued the memos and we carry out our work.
we carry out our work. Well, this is regarding to his past conduct, not the present. Tenor of the language is such. The whole thing is may not be that correct
Considering the first action of the Secretary of so-and-so, we did not file complaint.
this
See-
time. This time, they asked, why did you not raise complaint? We said that he was doing earlier also like this. He gave me later on. We used to put pressure on him. This was his conduct. Therefore, we did
But
not.
this time he kept us in dark and we are totally unaware of the unethical motive and action that
Yes,
he has taken.
taken. Well, in simple language, these Blaze people, they have written it in English. Expression may not be that exactly correct, but we have to understand the tenor, what they want to convey.
But it has to be understood what it is the language conveys,
My lord, yes.
not the convenient of
No,
the
My lord, well, I
what
understand.
the way it suits to
My lord,
the
it is not drafted by,
parties.
it is not drafted by a clever draftsman.
No, no, it's not a question of clever drafting.
Yes.
Whatever is drafted, we'll have to go. Since we are relying on it, we'll have to. I
Yes,
mean,
because
see
this was
to that-
submitted. This was submitted before them. Did they consider it appropriately? Did they consider it fairly?
So then come to this, further due to non-issuance of memos and
Further,
distribution
this is in
issuance,
further and so.
we are not able to submit the transportation bills for
Yes.
the month of April and May 2023.
Had it been the case that you have also taken the bill for this 2 tier, second tier also, but you did not deliver, there is no proof, then matter would have been different. They say, I have said, I have not even submitted bill because I could not perform my duty.
That is what you have not said.
Sorry,
That is, you have not said here in this reply.
my lord, in my responsible submission, this
It
is.
is
the-
you, the learned senior counsel, who is saying.
No, my lord. It is the. it is
Since
the-
you are reading the
very
reply of the
purport-
petitioner, we'll go by the language.
The very purport of the expression and as a whole reading gives the same impression. That's why I am trying to convey. I cannot add anything, my lord. I cannot add. I cannot add. What I am saying is further. This is further. Further to what have been said above. We say that due to non-issue of memos and distribution of they will have to issue memos and this, then I am liable to distribute. Since they have not issued memos and distribution of the
according-
rice.
You have not done the job of transportation of this tier 2. That is your case.
Yes, I could not do. I didn't do. I could not do. It was not allotted to me. Therefore, I could not. Earlier, allotments were made. I have given all these papers. How allotments are made by them and I distribute. Right from Malad. Page 37, 38, 39. I have given all this. This is how they used to make allotment and then I transport. This time there was nothing of that sort.
See, your
GPS
agreement is for, you have continued, see, number one, your agreement is both the tiers,
What did you?
1 and 2.
Yes.
And serial number 6, clause number 6 of the agreement, page 31 says, the transport contractor, that is you, shall deliver the allotted food grains transported by them to the nominees so and so in tier one and to fair price of the tier two properly without any loss, damage, shortage of its quality and quantity.
Yes,
It's obligated on you.
yes.
You just cannot say
No,
that,
that is why I said.
you
except-
just cannot say that, I have done the tier one and my hands off for tier two because they are not issue. It's your obligated on your part as per
No.
the agreement.
My lord, it also fact remains
Huh.
that when I deliver to the godown of another authority, unless that authority gives me the permission.
And serial
keep
number
it.
7, clause 7. The transporter shall obtain a receipt from the LOT, so and fair price shops. After successful, the transport food grain duly signed the receipt and countersigned by the executive officer or the concerned so and so. Transport shall be responsible any loss, damage, leakage, replacement, inferior quality, so and so food and shall have to be transported for all other first as per provisions of law. See, even if you are assuming that you have not undertaken the transportation in respect of tier two,
Yes.
tier two, but as per the agreement, you are obligated.
No, man.
Yes,
My responsible submission is no.
yes.
Unless they can establish that I have been allotted with the.
No, it's not a question of allotment. You have agreed this this is the Thunder agreement you have relied on.
My lord, this indicates. that-
Number 2 says you have agreed to perform both the tiers.
Yes,
Then
true.
clause 6 says, what does it say?
What it says, I am responsible. Once it is in my possession, I am responsible.
No, it's not a question of,
But-
you are supposed to, it's your duty to get it done. Because you have agreed to perform both the
True.
tiers.
I cannot deny. I will not carry. Once it is given to me, that is why it is binding on me. Kindly see what they
Where
have
does
said
it say
regarding
in the agreement that the person has to be given? Unless it is given, you are exempt from carrying out that
No,
tier
well,
two.
it is, but how this system operates, let us see their affidavit, what the other side has said.
Ah.
Kindly see, they have clarified it. They have clarified at page 80. Lordship will kindly see. Affidavit in opposition filed by the Inspector of Foods.
How many affidavits?
One affidavit. One affidavit. One affidavit. How the system operates, well, that has to be looked into.
No. System I have understood. You have to be provided memos and instructions by the secretary of the
DPS.
society. I mean, what is it? Cooperative society.
Yes.
Cooperative society,
Ah.
that other one is.
I am also cooperative society, I am a career, but I give it to
CPSS.
the other cooperative
CPSS.
society. They will have to allot it to me, memo should be issued to me, and I will carry it and deliver it to the food,
The
price,
fair price.
what they call it, fair price shops. Fair price shops, I have
And
to deliver.
ultimately goes to the.
Then it goes to the
Ah.
people.
At
So
a
my-
very subsidized rate.
True. My question is, if this was admittedly not done by them, how can I be held responsible for that? Can you see at page 80, paragraph 6, what they have said? Lordship got it, my lord? Paragraph 680. That the amendments made in paragraph 8 of the writ petition, the deponent begs to state that on 12/6/2023, the inspector FCA and CA has submitted a detailed inquiry report to the respondent number 4. Further, the deponent begs to state that as per the report, a huge quantity of PAMGKAY rice has been diverted by the secretary and other office bearers of Messrs. Namrup GPSs. They are saying it is being done by them. And in league with the transporters is so and so. They will have to prove it. See Gokul Das and others. In the said inquiry report, it was found that the Messrs. Namrup GPSs did not issue rice to 15 numbers of fair price shops dealer for the month of May 23, which amounted to be so and so quintals, and so and so quintals for the month of June, and all total 154,165 quintals rice have been embezzled and diverted, by which depriving the 19640 families with a population of so-and-so who have NFSA national card. Kindly see, they have directly said it is number of GPSs. They have not issued.
No, no, and in league with the transporter of MS.
But they have not issued, they have said, Mala, month of so-and-so, amount of so-and-so, rice have been embezzled by them, diverted so-and-so, families with so-and-so.
As per the report, the present secretary Shri Prabal Borgohain gave a statement in writing, and where he has admitted that so-and-so rice had been sold out to Shri Mani Saha alias Shri Saram, who is acting on behalf of the transport contractor MS so-and-so, your
Yeah,
society.
yes. Who is acting on behalf of the society?
They bought it sold in the open market in collaboration with other so-and-so. Inquiry report is
Therefore,
sufficient to
Therefore-
terminate and
therefore, my lord, my respectful
terminate the
submission,
contract.
my respectful submission is, on the face of this statement also, when they have their cases.
Sir, as
Right?
you know, sir,
Yes,
you
I'm
know
saying-
better than this court.
No,
It's not a question of, it's not a criminal trial
Yes, yes,
or the disciplinary proceedings
yes,
where it has been proved reasonable doubt or the probability.
yes.
It is simply an inquiry. Based on the inquiry, the action has been initiated, your contract has been terminated, your being propriated. That's all.
My lord, in my respectful submission, true, true,
If there are materials,
true. Well, my submission is there. There is no such materials
there
which can
are.
be presently used against me to terminate my
You are
contract
reading
and to
here
profit.
only. Para
Because
6.
it is in league doubted. Only doubt will not do.
That's why it's not a criminal proceedings.
My lord,
There was an inquiry.
criminal proceeding is going on.
That will, you,
PS case is going on.
yes.
They will have to. Therefore,
That is another
therefore,
issue.
by one of the
So there,
statements,
whether they will prove or not, that will be.
my lord, that is why in one column, Lordship has read it, I have read out. The Sopan Jyotish said, when asked for, the report says that if ultimately it is found, proved that I am really responsible, I will have to bear it. I cannot escape responsibility. But
Where?
but in the criminal case, that is what they say.
Where today we are not concerned
But
about criminal. We are
because-
based on the
Yes,
material.
but because in a nature of this inquiry, whether there is any doubt or just without any concrete material is enough to penalize a person which has serious civil consequences. Giving an opportunity of hearing enough is not enough. There must be some reasonable ground to conceive that yes, there is no other consideration. There is no other view can be taken on the face of this. Then of course,
As I've indicated, as per the agreement, you are obligated to carry the tier 2 also. You said just because the fair price was supposed to issue, maybe you have put your hands up.
yes, I
That
can,
that is not your job.
no, my lord, all.
Your
respect-
duty to
with all
get
respect,
it
my lord.
done, and you have to. Because
but-
as per the agreement, you have said you will taken
I am,
transportation of both the tiers,
yes,
right?
yes. So
Just
therefore-
because a fair price shop is not issuing a memo, and you have admitted in earlier occasion also they have not done it, but
No,
you have
they-
kept quiet. You have not informed
they
to the
delayed.
authority.
In the earlier occasion, so they delayed, therefore, we used to pressurize him and therefore he issued ultimately, in earlier cases. This time he was also sitting tight. Our pressure didn't work and therefore he ultimately played.
And
cock.
you also kept quiet.
No, my lord, I have no option.
And you have because you have kept quiet because you are in league with the Namrup GPS,
My lord,
GFS,
my lord,
GPSS. And then you have engaged you have solved the thing who is acting on your behalf.
my lord, that is, kindly see, my lord, on the face of their own statement, this is a requirement to complete my part of the second tier. Page 80, they have themselves said that in the said inquiry report, it was found that Messrs. Namrup GPSS did not issue rice to 15 numbers of fair price shops. To whom I am to deliver? Unless I am told that these are the shops where you are to deliver this much of quantities. They give us memos indicating not only the name of the shop, but also the quantities to be delivered. Accordingly, I go. I have not denied that they have allotted me. I denied, no, I will not carry it.
Okay.
Then, of course, I am
So
responsible.
this para 6 obviously is an counter affidavit will go against you. Don't rely on this.
No, this speaks about the fact prevailing. This is the fact prevailing.
Okay.
That is the fact prevailing.
Okay.
So,
Edit.
in my response submission,
Sir,
they
please
have-
make your submission now.
my lord.
It's
my
been
response
1 hour.
submission, They ultimately lordship will see.
Please don't mind. It's been 1 hour. Please make your submissions.
Yes, my lord.
If you want to rely some judgment or you may
I
rely.
am concluding, my lord.
Yes, please.
I am concluding. Under the, my lord, I am just taking a lordship once more.
Yes.
To page 76. Last, page 76, last few paragraph, whereas Messrs. Namrup GPSS, lordship got it, my lord.
I have read it already.
Yes. Has
In
not
fact,
distributed-
yesterday evening.
Yes, but now reading together has a different,
Yes, yes.
a different, my lord, kind of,
Yes, yes.
please,
I'm just on that.
please,
Yes.
Messrs. So-and-so, Namrup GPSS has not distributed TDPS rice to the FPS dealers for onward distribution to the beneficiaries within the government stipulated time frame. This is a categorical finding by them also. Once more, whereas Messrs. Namrup GPSS has not distributed TPDS rice to the fair price shops dealers for onward distribution to the beneficiaries within the government stipulated time frame, so and so, so and so, and June 23, so and so, so and so, a part of so and so, so and so. They have said that these were not issued by them for so and so. A quota is believed to be diverted. That quota is believed to be diverted into open market by the transporter so and so in league with the office bearers of Messrs. Namrup GPSS. My lord, this is my responsible submission. This itself is believed to be is not enough to punish me. This believed to be is not enough to punish me because apparently the Namrup has not issued for distribution of this thing, the prices, I mean the rice to the GPS level.
Are you
Yes.
saying Namrup has not distributed?
Yes. Therefore,
How he will distribute it? Because you have not transported.
no, they have not said that I have not transported. They did not issue. My concern, they did not issue. And they have also said they have not issued memos to me. Therefore, I could not do it. Therefore, embezzlement on my part will not arise because it is within their custody. They are in custody. That godown is in their custody. I have no access to it. Once they receive it and put it in their godown, I have no access to it.
You fight it out in the criminal trial.
Well,
Are you accused? Are you accused there?
Yes. One of my employees were there. One of my employees were there.
It's only a termination of contract
With professor of 10
and
lakhs
professor of 10 lakhs.
and lakhs, my lord, for a
You
cooperative society.
better fight out in a criminal proceedings.
It is
We'll
co-
decide this
It is
matter.
cooperative society. No,
Ah.
my lord, lordship will definitely decide. I am only asking for a decision from this honorable court. It was pending for long. Therefore, only thing is
It's not
lordship will
pending, it's
consider this thing.
2024.
Yes, kindly consider.
Today we have adjourned 2016 matter also.
Happens, but the service goes on. We are affected badly. And here lordship will see, I am on because their own report saying, whereas Namrup has not issued memos, they have not distributed it. This is said, but their fault, and we presume that we are also in league with them. This presumption will not have any value of law here. This is my first submission. Then,
Because you have not performed your part of the contract.
yes, I have not been entrusted with the job to do it, therefore I could not do it. That is
Who
my
has
plan.
not given to you?
First entrustment must be there. Then this operation of that.
That's
that
why I'm
clause
saying
six.
it doesn't show anywhere in your agreement with the department
Well, it
that
says
it
that
has to
first,
be
I'm,
done.
in the first year, I am to deliver it to their godown.
Huh?
Second year, I am to distribute.
And you
So
have
from
agreed
their
to,
godown,
you have agreed to do that.
yes,
It's not a
to
question that you,
visit it.
the permission should be taken from the department.
my lord, no,
It is the society or the cooperative society who has to give you memos.
yes.
It's your part, which you have said also in earlier occasion also, they have not issued so, but you have insisted. This time also you could have done it.
My lord, take it.
And you have
let
taken
us-
the
let
matter
us-
to the concerned
my
authority
lord,
also, that
I
you have
agree,
not
my lord, I
done.
agree. Let us take it that I did not insist.
Huh?
It is their duty bound. My insistence is not.
Is it a duty bound of the authority?
Yes,
Not authority,
no, duty of the cooperative society.
cooperative society.
They will have to discharge it.
They are equally,
This is an authority under the department.
therefore this authority,
They are holding it in their own godown. I have no access
see,
to it.
the authority wants you to transfer both the tiers. You are the transporter
Yes,
of this Kamro.
yes.
It's your duty.
My lord,
Under the country, you are
that is
bound
why,
to.
lordship,
I understand. They have not, let us assume
Well,
that they
that
have
is-
not issued.
my lord, in my
But it's your duty to get it done, get it issued, which you have done earlier also. This time you have missed.
my lord, let us take it.
So
I discharge it.
maybe practically you may not be there. But on theoretically, because you have not performed your job duty, therefore you are also liable to be, I mean,
My lord, that is, to that extent,
penalized, liable to be penalized.
penalizing, to penalize me on the basis, by considering that clause 6 lordship is referring to. This has its application only when the second tier begins. The second tier begins with the allotment.
You have to get it begin. You have to get
lord,
it, not only begin, you
Even
have
if
to
I
get.
try and I may fail,
No, you
what
have
can I
to,
do?
you have to get it executed. If you have failed it, you are liable to be penalized.
my lord, on that ground, I have not been penalized.
That is your ground.
On that ground, I have not been penalized now.
May not be.
I have been penalized that I have diverted it.
That is your submission that you have not done. According to them, you might have, you ought to have
What-
been done it. And if you are not doing it, you are in league with the Kamrub GPSS. Therefore, you are also
No, but
liable.
they themselves say in this paragraph that the Namrup has diverted it.
Hmm.
They have diverted it, but in league of, without, in league of this transporter. But
Include
when the transporter
thereafter-
has given it to their godown, it was in their possession. How come I get involved to it?
Then there's a further statement by the stand of the authorities saying that by naming a particular person, that he has acted on your behalf. Sri Ram or something like that.
Someone, some sahu. An individual may be involved there, it is a different thing. If at all there is some individual involved, not with the contractor as such, transporter as such.
Manisha
One is sahu,
Sah,
one is sah or sahu.
alias Sri Ram Sah,
Ram Sah.
who is
Sah.
acting on behalf of the transport contractor MS.
That is only a presumption. He has not been authorized, he is not the secretary, he is not, no authority to.
That's
deal
why this
on my-
person has been acted on your behalf.
He is not authorized. to-
Because if the secretary of the society then he'll be caught
No,
red-handed.
if the secretary is there.
There is a modus operandi of these people who
Well,
was for all
but
this.
in law, lordship will appreciate better.
Hmm.
In law, something specific must be there. Something specific must be there.
Sir,
Therefore, my
as a-
actual submission, what is lordship?
To my understanding, this issue of proving the guilt beyond reasonable doubt or the probability, preponderance of probability,
Yes.
it depends in the civil and criminal matters.
Preponderance of probability.
This is clearly penalized under the contract.
My lord,
Penalized under the contract
my lord,
would be a different so far as the proving of the case is concerned. Obviously, in a rich jurisdiction also, it has to be proved.
Oh.
But it's not as the requirement of proving in the pure criminal and civil trial.
No, I am not asking for that. My contention is that there must be some concrete materials
Hmm.
which can be directly related to me, to find me to find me guilty.
What is this, sir?
Well, that's exactly similar matter. A collateral bench of this honorable court decided
Hmm,
this issue
hmm.
and interfered with the order. That is why I am placing it before your lordship. Exactly similar issue. According to the writ petitioner at paragraph 4. According to the writ petitioner, the transporter of food grains allocated for the year 23 from the FCI godown to the respective WCS GPSS was duly executed by him, thus completing the tier 1 level of transportation. However, due to non-availability of requisite orders, memos from the concerned WCCS GPS for the tier 2 transportation, the petitioner could not commence the work of transportation to the respective fair price shops, even though as per the terms and conditions of the contract, he was required to transport the goods to the fair price shops dealers within 15 days. It appears that some malpractices on the part of some of the office bearers of GPSS Limited was detected by the authorities, and on 31/5/2023, an azahar was lodged before the officer in charge, so and so, Dibrugarh, district Dibrugarh, by the Inspector of Food and Civil Supplies, Affairs, Consumer Affairs, Dibrugarh, alleging foul play on the part of the chairman and secretary of the Messrs. Roh Moria Sambai Samiti Limited, leading to diversion of high subsidized price made available under the NFSA 2013 based on the aforesaid Azaha. Ramari PS case number so and so was registered under section so and so and the section 7 of the EC Act, and the matter was taken up for investigation. During the course of investigation, the chairman and the secretary of the Ramoria Sambai Samiti Limited were arrested by the police. The matter is currently under investigation. It appears from the materials available on record that the allegations of the diversion of the rice bags from the godown of Messrs. Ramoria so and so situated thus so and so, Ramoria so and so, situated thus on 21/5/2023, the response number 3 had issued a show cause notice calling upon the writ petitioner to show cause as to why contract agreement should not be terminated and the value of the realized. 6. On receipt of the show cause, they have given show cause, they have referred to. By referring to materials available on record, so and so has submitted that. Lordship may skip over these submissions also. Then court has referred to the terms and conditions of the contract at page, internal page 7. And then court has come to the conclusions. A plain reading, paragraph 11, a plain reading of the above mentioned clauses of the contract agreement made particularly clause 8 would clearly go to show that the responsibility to ensure timely loading and uploading of food grains by the transporter contractor was on the district authorities. It is the district authority's responsibility. The aforesaid clause of the contract agreement, when read in the context of other clauses, would clearly demonstrate that the responsibility of the contractor was only to adhere to the lifting program of food grains provided to him by the authorities, FCI. The contractor would be bound to complete the transportation of loaded food grains within time. The lifting of food grains and the delivery of the same were, however, to be carried out under the supervision of the district authority. In other words, the terms of the agreement governs duties and liabilities of the transporter in the matter of transportation of the food grains and the issue arising during transit and not beyond that. Under the terms of the contract agreement, the transporter would not have any liability to repeat to respect, in respect of the food grains while the same is stored in the godown of the WCCS or GPSS. Moreover, the contractor could also not lift the food grains at tier 1 or tier 2 level unless instructions for lifting of food grains and the delivery address was given to him by the concerned WPSCCS. This is the same thing here, madam.
No, in the present case, materials on record indicate the average of the food grains by the mechanism as projected by land government SM was detected while food grains were stored in the godown of so and so, so
Yes,
and so.
Rahamoria.
The contractor transport does not have any access
Access.
to the goods stored in the godown of the so and so during the period which the goods are stored in the godown. These facts are little different.
The
Is
responsible.
the finding of the court, the responsible storage of the good would lie on the consent and on the authorities in charge inspector under whose supervision so and so are located. There is no obligation against it priest to the effect that he had direct role to play in the diversion of rice bags. There is only nothing on record to show even indirect involvement of writ petition in the diversion of bags. Anyway, we'll consider.
So my response submission is, those terms have been considered by this honorable court in this particular judgment and has explained it, how to implement it, how the responsibility so far the transporter is concerned accrues, when.
They have, court had said the clause 8 and 10 only.
Yes,
Not
8,
the
10,
clause 6.
8, 10 and 6.
Huh?
8, 10 and 6 I say.
6, 7, 8, 9, 10.
Yes. Yes, 6, 7, 8, 9, 10. The court has considered all these clauses and has come to the conclusion that it is the responsibility of the district authority first to see that the time schedule is maintained. Under their supervision, they do it. Therefore, I have no such responsibility that I should at any rate get it done. I can only tell them, but if they do not go ahead, I have no further any responsibility to compel them to do it. Therefore, here also, court says that as noted above, there is no even an iota of evidence on record to suggest that the writ petitioner had acted in violation of the terms and condition of the contract. The writ petitioner is also not named in the FIR. As such, having regard the facts and circumstances of the case, it is opinion that there is no cogent basis for the response number
Okay,
3.
I've read it.
So my response submission, this squarely covers my case. Interpretation has been given. Therefore, I earnestly submit. My lord, my responsibility comes only when it is formally given to me. I have no access so far their godown is concerned. And even if I take it that I could not initiate, could not tell them that you do it, your part, that by itself will not be fatal on my part. They cannot. There must be some definite material, evidence on record to establish my guilt, prima facie. So to attract civil liabilities to the extent of forfeiting my license as well as the contract, as well as the confiscation of the
Not
security.
your license,
10 lakh.
contract has been terminated.
Contract has been terminated. Therefore, this should be interfered with. This should be interfered. Let the criminal case go ahead. If somebody is found guilty, obviously it will take its own course. But so far the civil liability is concerned, in my responsible submission, there is nothing
Yes.
whereupon the impugn order could have been passed. Deeply, subject to what my learned friend says.
No, no more. No more reply.
Yes, I have done my, I have done my part.
Done
Let them-
everything.
Warren,
My lord, the whole case of the petitioner is that on mere doubt, his contract was terminated and the security money was forfeited. My lord, there is no question of doubt or anything, because this is an admitted position that for tier one, he has done his duty. For tier two, where he was obliged to distribute it to the fair price shop, he has not given for those 2 months. That is an admitted fact, but how and why he has not delivered? This is not a fact to be considered because he is bound by the agreement for both the tiers from lifting it from the FCI godown to the GPSS godown and tier two to the fair price shop. He is duty bound and he is bound by the agreement. Agreement your lordship has seen, my lord, the clause by clause your lordship has gone through. So we have terminated the contract in terms of the agreement, nothing beyond that. Nothing beyond that. That clauses your lordship has already read, I will not trouble your lordship to go again. Now, clause 6 says, clause 10 says, my lord, the transporter shall be responsible for any loss, damage, leakage, theft, replacement of with inferior quality of the transported food grains and shall have to compensate for such irregularity. Besides, liable to face prosecution as per provisions of law. Now there is no question of loss, my lord. The entire quantity has been hussed up. This has been diverted and our further information is sold in open market, my lord.
Huh?
That was sold in open market. One
From where you are saying?
inquiry, we have done preliminary inquiry, my lord.
Hmm.
Although those materials are there, my submission will be, I need not even go to that. He is bound by the agreement. The tier two also, he is bound by the agreement. If he was, the receipts were not delivered to him or no mandate was given to him to lift the food grain from the godown, he could have informed it to the authority and he could have even lodged FIR or some civil suit maybe. Because he was bound to deliver it to the fair price shop. Apart from that, lordship, we have materials, some materials, I am not. Lordship may come to page 88 in our affidavit of opposition. This is a confessional statement of the Secretary of Namrup GPSS. Page 88, Annex C. Has your lordship got it, mind? Third paragraph.
Page 80,
Annex C over it.
88.
88 maybe, 88. This is a statement of the Secretary of Namrup Samabhai Sabha. Third paragraph, your lordship may see, it is a fact that I bought the 1,000 so and so quantity rice sanctioned in the month of June from FCI Dibrugarh, but the rice was not stored in the godown of the cooperative society because the sanctioned quantity of rice was sold out. I sold the rice so and so to vehicle supplier Moni Sahu on behalf of transporter so and so. I came to know from the conversation with Sahu that the said rice is being sold in the black market in the direction of Sri Gokul Das, the present secretary of so and so. Not only they have, my lord, it is he who purchased the rice from the godown and sold it to the open market. But I will not rely on this. I may not, because he is bound, my submission will be, he is bound by the contract for tier one and tier two, and he has paid. Therefore, we have terminated the contract. Under the contract agreement.
This inquiry report, page 60, Has it been furnished to him?
Page
60. Preliminary inquiry.
preliminary inquiry report. Yes, ma'am. Physically missing from the godown.
Has you, has this, okay. This is by the inspector to the deputy director.
Yes. This
On-
was the preliminary report, then there was a final report.
On this basis, only FIR was lodged, right? And then suppose notice was issued to the petitioner. Okay.
Yes.
Yes.
And therefore, my lord, I say what my submission will be that leaving aside these things, he is only bound by the contract. So he miserably failed. He knows that that is an admitted person. He did not perform the tier 2. Therefore,
Is it not your duty to, I mean, take care that the cooperative society who has to, I mean, issue the memos and
for lifting.
lifting from
That
that,
was not given to him.
huh?
So that was not given to him. Therefore, he could not supply. That is his experience.
So is it not your duty?
He has never reported to us.
Huh?
Well, he never reported to us.
Hmm.
He could have done so many things. He could have reported to us, district authority, could have gone to police, could have filed a civil suit, because he is bound by the contract. Even if somebody fails, he cannot absolve his responsibility. And he cannot push the buck to the other society, because in that case, where is the Namruk society is a party? There is not a party respondent here.
You will not make him a party because
Madam,
your allegation
because
is in league
his
with,
entire case
in league
is
with
that I have not done anything. He
number
has.
of GPSS is in league with the petitioner.
We have probably dealt with them also separately.
So how they will make him a party?
He says that I have not done anything, only he has done it. Now our case is your violation of the contract agreement, we have, so your agreement is severed.
Okay, understood. What about this coordinate bench judgment? You see it, share it, one copy, share it.
Maybe different,
Almost-
factually maybe different.
Almost the same.
Maybe, but there may be
Because
almost.
Your
same
language
only-
is also same, terminated, refunding, and the share from the other GPSS.
That of course. I have
Language
not-
is same,
I have not-
Dibrugarh district, same deputy commissioner.
I'll go to it. Maybe some.
So basically,
Mr. Talukdar.
there was
appeared
no
in this case
material
also.
according to them.
You appeared in this case also.
I'll go through it.
You have appeared, Vijay Talukdar.
You are good to case there.
I'll go through it. Maybe some factual difference. Actually, maybe some difference. Yes, copy me. And I'll go through it. Difference as in-
It has attained finality,
Yes.
no appeal, nothing.
have any information.
Huh?
I don't have information.
No appeal, मतलब 2 hour knowledge. That's- Funny.
Iba send difference.
Same argument,
Yeah, man.
para 8.
I'll go through it. Lost in
You have made the same argument. So this order is a hiccup. Otherwise, there appears to be a complexity. Look into it.
मतलब
You have heavily relied on this judgment.
yes,
He had made the same submission.
yes. No, but he was arguing on behalf of the other side in that case.
So go through it. We'll take it up at 2 o'clock. Or maybe after at 3 tomorrow. Very difficult.
You will have to only say on this. Slide. That too, you go through it.
And Mr. K. Mohanta, learned senior counsel assisted by learned counsel for the petitioner. And also had Mr. B.J. Talukdar. Then senior counsel assisted by Mr. Or state respondents. A hearing to continue tomorrow, only for this. Rest, no argument. Just no argument. It will be parted, not parted. In fact, we have conclusion, we have concluded the hearing. Only
not to
to,
record.
only to
Give him
chance to clarify what
clarify on that.
on this judgment.
Yes.
Judgment goes on. 8 copy রাখুন।
আছে না আমার?
Hearing continue tomorrow. List so and so. 2 minutes. Tomorrow 2 minutes. Huh?
There is any difference?
Probably I would have nothing to add more because you will have to clarify that judgment is enough. I have placed. My friends will be there tomorrow morning.
No issue.
Alas, in this case, I'm been led by senior counsel, Mr. K. N. Chaudhary. He is on vote number 1 on legs. Well, after some time. This matter pertains to the land acquisition.
You are for?
For the landowners, Your Lordship.
So you have accepted on protest, according to, and and thereafter you filed the reference.
I was,
You
went
filed a
for the
reference.
reference. I sought for a reference. The collector declined. Collector didn't take any action. Then I filed an application under the proviso to section 64 before the reference court. Reference court then having considered my application, he directed the collector to refer the matter. Thereafter, section 65, and the matter is now pending before the district judge, the reference court.
It has been referred. Okay. So against that only,
They are coming.
okay. So how much you want? How much you have received and how much more you want?
My land what I'm seeking is for per bigha. 300, na? 30 lakhs. 30, around 30 lakhs, I'm seeking.
How much you have received?
They give us for 4 lakhs. Per bigha, so 600 bighas.
No, they have already got around 75 lakhs.
Is it under?
The 7 crore.
Compensation will have to be determined, Your Lordship.
No, you have received 79 lakhs.
I've received, that is for 600 bigha,
79 lakhs.
taking the market value of the land as 2 lakhs 40,000. I'm seeking enhancement to 30 lakhs, Your
Well,
Lordship, because of
75 crores.
Per bigha.
per bigha.
Okay.
I have materials I have there to show.
Sorry.
Wait, please. My lord, for expansion of the Numaligarh refinery, some lands were acquired. Our case is, my lord, without any objection, they have accepted the award. Now it is not open for them to, my lord, apply for, my lord.
Reference.
Yes, reference. Now, if you just to place the facts in perspective, my lord, if your lordship would kindly come to page 70.
Yes.
My lord, this is a communication by the Office of the Deputy Commissioner on 10/5/21 to the my learned friend's client, that is Mosak Agro Private Limited. This is here to hereby inform you that Numaligarh Refinery is to acquire your industry name 600 bighas of T Miadi land, Patta number 2 of so and so. In the matter of the above land acquisition, if you have any objection, then please inform and specify within 25/5/21 in written form to the undersigned. So, my lord, a proposal was mooted and it was forwarded to the Tea State, my lord, and they were invited whether they have any objection. Then, my lord, will kindly come to page number 72. Now, the director of the respondent number 3 company writes, with reference to the above letter for proposal for acquiring our land by Doug number so and so, we hereby agree to your proposal as mentioned above in your letter. So in principle, they conveyed, my lord, their acceptance that they have no objection if their lands are acquired. Then, my lord, will kindly come to page number 61. These facts are necessary, my lord, to appreciate what we intend to say. Now, this is a communication from the government to the Deputy Commissioner, my lord. The land acquisition compensation was approved. So it was approved at 79 lakh crore, 58 lakhs and odd. Am I clear, my lord? Then at page number, my lord, 63, after the government approval was received by the Office of the Deputy Commissioner, the Deputy Commissioner's office wrote to the Numaligarh Refinery. With reference to the above subject, I am directed to enclose herewith a copy of the letter dated along with approved copy of LA estimate amounting to 79 and odd crore, only and arranged to deposit the same by check, banker draft to the Deputy Commissioner Golaghat for subsequent deposit into the bank for further disbursement of the land value. So, my lord, additional Deputy Commissioner informed the Numaligarh Refinery that this is the amount which should be required, you better deposit. Then, my lord, at page number 65, the Numaligarh Refinery, my lord, writes to the Deputy Commissioner. With reference to the above enclosed, please find herewith a draft bearing dated so and so. So as the authority for whom the land would be acquired, my lord, they have deposited this money with in the bank maintained by the Office of the Deputy Commissioner. Then, my lord, will kindly come to page number 74. This is very important, my lord. With reference to the subject cited above, I am to inform you that Numaligarh Refinery Limited has deposited an amount of rupees so and so, only being the cost of the land and Jirat in regard to LA case number so and so, which has already been deposited into savings bank account of the Deputy Commissioner Golaghat. Therefore, before releasing the amount of the land and Jirat in regard to the above mentioned LA case, you are requested to hand over formal possession of 600 bighas of land to Numaligarh Refinery, the authority in consultation with circle officer for taking further necessary action. NRL authority may also be suitably informed. So, my lord, the office of the Deputy Commissioner informed the T state that you hand over the land in question. Then, my lord, lordship will kindly come to page number 67. The tea garden, that is respondent number 3, writes to the Deputy Commissioner's office. With reference to the above, we are ready to hand over advance possession of the land to the Numaligarh Refinery Limited. So, my lord, they say we have no objection, we'll hand over. Yes. Then, my lord, will kindly come to the last para at page 67. As per company's law, all document, operations, transactions should be executed and signed in the name and on behalf of Mokoksong Agro LLP only due to conversion. In the meantime, my lord, in the status of entity, my lord, there was a change. Now it has become an LLP. As such, the amount of compensation should be released in the name and bank account of Mokoksong so and so. So as far as the, my lord, the quantum of compensation is concerned, they had no objection. They have accepted merrily. They said instead of Mochak Agro Private Limited, which was a private limited company, money should be released in the bank account of that LLP. Then, my lord, will kindly come to page number 74.
$74 you have referred already.
I'm sorry, 76, my lord. I'm sorry.
Yes.
On 18 September, NBC writes to the T State, my lord, that with reference to the above, I am to inform you that NRL authority has placed the required fund for payment of award of acquisition of 600 bighas of land. The said amount has been deposited in the savings account of the Deputy Commissioner Golaghat in so and so. Accordingly, to release the amount, you are requested to submit the following documents: indemnity bond, Jamabandi, Khazana Rasid, and my lord, account details. So, in order to facilitate release of the awarded compensation, my lord, these documentations are required. Therefore, they were asked to comply with it. Then, my lord, will kindly come to page number 69. In the meantime, my lord, the award in form was duly notified on 17/11/21. With reference to the subject cited above, I have the honor to submit herewith Form 10 for land acquisition award duly filled up in connection with acquisition of 600 bighas of land of Raspberry Tea Estate owned by Mochak for Numaligarh Limited. Then, my lord, will kindly come to page number 78. Respondent number 3 furnish the indemnity bond, cancel check, affidavit, etc. 78. Then, my lord, at page 11, at page, my lord, 84, there is a minutes of meeting. Now, what had happened? A minute of meeting was held on 5/2/22, my lord, in the guest house of NRL, which was attended by Chief Minister, my lord, where there was, my lord, agreement regarding acquisition of the land. There was no dispute. Nobody raised any objection. Then eventually, my lord, this is most important at page 86. Now, respondent number 3 is writing to the Deputy Commissioner. Kindly mark the date, my lord, the 19th of February 22. With reference to the above and discussion MOM dated 3/2/22, that is the meeting which was presided over by the CM, and as advised in the meeting dated so-and-so, chaired by so-and-so, the compensation amount can be released after deducting the amount payable to the eligible workers. So that amount of 79 crore and odd, which is eventually the part of the award, my lord, they say they have no objection, no nothing. Now it can be released after the sum payable to the eligible workers. Then my lord will kindly come to page number 88. This is an affidavit filed by respondent number 3, my lord, that the Deputy Commissioner Golaghat District may release the compensation amount payable to the aforesaid LLP against LA case number so-and-so for acquisition of land measuring 600 bighas being acquired for Numaligarh Refinery Expansion Project after deducting therefrom the amount of compensation payable to the eligible workers as per MOM dated so-and-so and as advised in the meeting dated so-and-so by the Honorable Chief Minister. So on oath also, they affirmed that they have no issue, that money should be paid. Then eventually, my lord, kindly come to page number 90. This is
Yes.
on 14th of March. Now, this is my lord, Mochak is writing to the Deputy Commissioner with reference to the above and against the acquisition of land measuring 600 bighas out of the land measuring 652 so-and-so in the district of Golaghat, an amount of rupees 63 million, this is after deducting the amount payable to the laborers, deposited through online transfer in our bank today on 14/3 so-and-so. So the money was deposited in their account on 14/3/22. They acknowledged it. We confirm the receipt of the above amount under protest as to sufficiency of the amount and without prejudice to our right. Now, my lord, this is on 14. They say that they have received the money. Am I clear, my lord?
Yes.
Now, this is a type copy. Please come to page 91. This letter was received by the office of the Deputy Commissioner on 16. My lord, it is not slightly, it is illegible, but the receipt portion of the office of the Deputy Commissioner, the date is very clear, 16th of March 22. So, my lord, their objection is dated 16. They received the money on 14. But eventually, my lord, in February 22 itself, they have given their agreement, my lord. So, this is the factual position. Now, question is, once having accepted the money, now can you, having accepted the money without protest, now can you now lay a claim for enhancement? That is the point to be decided. My humble submission is, my lord, there are series of judgments of our High Court, of the Supreme Court. It cannot be done. Now, let us come to the, my lord, the statutory provisions, my lord. এখন দেখ না 13 আর এখন
The payment was received on 14.
No, my lord. Physically, it was received on 14, but on this date itself, my lord, if your lordship would kindly come to page 74 for a moment, my lord. Sorry. Page 74 and 76, I have read these two letter. My lord, by this letter, Office of the Deputy Commissioner informed the respondent number 3 that in order to facilitate payment of the compensation, he must deposit all these documents. That is indemnity bond, jamabandi, etc. Which he did, meaning therefore, my lord, he had no objection. And the affidavit which was shown on, that is also very clear, my lord.
10/3/22.
Page number? Page number 88 is the affidavit. Sorry, my lord. Page number 86, please come for a moment, my lord. This was on 19th of February. Release of compensation is the subject, and this is a letter by respondent number 3 to the Deputy Commissioner. With reference to the above discussion and as advised in the meeting dated so-and-so at NRL Guest House chaired by CM, the compensation amount can be released after deducting the amount payable to the. On this date, he should have been said that sorry, we cannot accept the amount because according to us, this is not sufficient. Therefore, we are contemplating to take legal recourse. Under protest only, we were accepting. Then, my lord, it was followed by an affidavit at page 88.
10/3/22.
On 10/3/22, that the Deputy Commissioner Golaghat may release the compensation amount payable to the aforesaid LLP. How can on 16, my lord, they become wiser and say, no, sorry, we are accepting but under protest?
Just so.
Yes. On oath. Delegate Goyal. দেরিকে করে।
Yes.
So, my lord, factually, what is clearly evident is that on 10/3/22, on oath, they say release the amount. If you had any objection, you could have said that. So, factually, this is the matter is. Now, my lord, I'll have to place before lordship the two provisions from the Act of 2013 and few decisions of the Apex Court. Whereby, my lord, the learned trial court below has committed serious error in, my lord, allowing the petition of the other side. My lord, there is some problem today in the second half. Can I make my rest of the argument after Thursday, my lord? If it is not inconvenient, or I can do a little later, maybe at 3:30, or Thursday will be convenient, my lord. Yes.
Mr. K.N. Chaudhary, then Senior Counsel, assisted by Mr. So-and-so, huh? Sahiwala, the Counsel Body,
Amit Sahewala.
and Mr. D. Senapati, for respondent number 3. And who else are there? Recorded, huh? Hearing remain inconclusive. List for further hearing on Tuesday.
Thursday.
Thursday, it's okay. Thursday. Thursday is 22. I think 22. Will it be possible? I think the matter is very short.
Short.
Whether your protest letter can be accepted in the protest letter or not, that's all.
And that's the point.
Whether this court will exercise jurisdiction. Or whether.
Why?
Okay. That issue, yesterday, I mean, you may raise anything.
And of course, my lord, and we'll reply to that.
But let us try to shortcut. Cut it short.
laying down a law in respect of this issue. When is the protest to be made?
Law is already laid down.
Yes, yes.
Much.
Deeply.
Matters pertaining to Itanagar bench. Orders item 1 and 2, election petition 7 of 2024.
Yes, Milan. And as per the 14th of November order, Milan, we have filed our evidence. Almost 9 witnesses have been filed, Milan. That has been recorded. And Milan, there is one IA which is left, Milan, IA number 260. That is regarding the additional documents which we have annexed with the evidence. There are a few documents which were earlier not with us. We have filed.
IA 260.
260, yes, Milord. That is
Yes.
the only IA which is pending. Otherwise, Milord, the matter may proceed for the cross-examination stage, Milord.
Hmm.
That is the only thing. So, Lordship would like to take up that IA, Milord, 260, we will.
Yes.
Milord, the 260 has been filed under Order 7, Rule 14, Milord.
Hmm.
That is that provision, Milord. Lordship may have the CPC, Milord, that Order 7, Rule 14. It says, Milord, roughly, Milord, it says that the plaintiff, while filing the suit, should file all documents which he is relying upon. Or a list of documents should be filed along with the plaint. And there he must mention all those documents, whichever document is in his power and possession. And the second proviso is, if it is not in his power or possession, he should mention in whose power and possession it is there. And the thirdly, Milord, the third provision of 14, it says, Milord, ki with the leave of the court, if there's some documents are not there at the time of filing of the plaint, and it is subsequently, it comes to the plaintiff, with the leave of the court, he can place it before the court, Milord. So this is under 14.3, Milord. Now, Milord, the basic documents which we have filed is under 3 categories. One, Milord, Lordship will recall, Milord, we have a specific ground of dead voters.
Hmm.
So we have filed certain death certificate, photographs of the memory stones, Milord, and a Facebook printout where it shows, Milord, that particular person who has voted in those polling stations has expired. This is only to bring in those facts which are already pleaded in the election petition. Their name is there in the list annexure along with the election petition. Secondly, Milord, there is another issue of Form 26 where gun license were there with the return candidate. He did not disclose it. So that is another issue. And we have got certain documents through RTI. So which we are filing. These are all subsequent to the filing of the election petition, Milord. This document never existed at the time of filing of the election petition. And there is one document, Milord, regarding the postal ballot. It's an official document which we are placing on record through PW1. So, Milord, before going to this IA, Milord, there is one judgment your Lordship has passed on 21st of March 2025. That is regarding the striking off of pleadings, Milord. So, if I can take your Lordship to that judgment, so, Milord, 2-3 paragraphs, it will be clear, Milord, why I am filing this and why it should be taken on record in the interest of justice.
This is in which
21st of March 2025. That was that IA number 182. That judgment is there, Milord. All these grounds, there, Milord, in that judgment, all these grounds have been considered by your Lordship because the other side had filed a striking of pleadings. So there he has taken up certain grounds. These are the unnecessary grounds that should be removed. Where your Lordship has considered all this, dead voters, postal ballots, I have considered all these things and then has given a finding that these are material facts and specific allegations are there. So trial may commence. Now, what we are filing in the form of these documents are only to supplement those. Lordship has that. Lordship may kindly have para 27. Lord, page number 14.
Para 27,
Yes, my lord.
page 15.
Page number, my lord, it is 14, 14 of 28, my lord. It
Mhm.
starts with citations. And then 26, 27, 27 is the finding, my lord.
This order is
21st of March, my lord.
yes.
Yes, sir. 27. On perusal of the election petition, following pleadings are discernible pleadings pertaining to inclusion of dead voters, non-existent or bogus voters in the electoral roll of so-and-so polling station, booth capturing in so-and-so polling stations with the consent of the respondent, resulting into corrupt practices, non-disclosure of asset in Form 26 affidavit, thereby violating the mandate of section so-and-so, resulting in undue influence, thus leading to corrupt practices. So these are the grounds, my lord, in my election petition. Lordship has considered this in this. And then after that, my lord, para 28, page number 15, bottom, my lord. Next page, my lord. Bottom 5 lines. The complaint also speaks of entry of 28 dead voters in the electoral roll of the aforementioned polling station. The complaint of the petitioner dated so-and-so also made after finalization of electoral roll. It contains the fact relating to reception of 102 bogus voter and votes of 24 dead voters by the returned candidates, which may attract the ground covered under 101D3 of RP Act. So these are, my lord, I have mentioned, your lordship has also considered these things, that these are there in the pleadings. Now, my lord, the finding is at para 31.
Yes.
It is another, not a finding, my lord, this is another regarding dead voters. Because we are saying para 31, last line, the number of bogus voters provided by the petitioner would constitute material facts showing reception of these bogus votes by the returned candidates. The finding is at para 39, my lord. Now, considering all these things, my lord, at para 39, page 20. Lordship has that, 39. On consideration of above pleadings and on comprehensive view of the entire petition, as well as having considered in totality, in my view, pleadings disclose material facts and particulars, along with complete particulars may be lacking. Thus, I am of the view that the grounds of corrupt practice and the facts necessary to formulate complete case are pleaded, which would suffice to formulate cause of action. So, my lord, on this, lordship has held material particular is there. There may be deficiency in material facts are there. There may be deficiency in material particulars, but the case is made out. Now, my lord, based on this, along with the affidavit, we have filed certain documents. Now, lordship may now turn to that IA, my lord, 260, IA number 260, 260, my lord. What I have filed, I will just show, my lord. The provision I have shown, my lord, the judgments, your lordship judgment I have shown that the pleadings are there.
Yes.
260 para, my lord, 3. Page 4. Para 3, I have narrated all the documents, my lord. The first document, my lord, is a screenshot. Lordship has a 3A. Is a screenshot of the condolence message posted by the son Tai Logo in the Facebook page regarding the death of his father, Tai Nilo, on 6/3/2022. The election was in 2024, my lord. Now, this, which proves that a bogus vote has been cast against the epic number at 16 Pagba polling station. The said Facebook post came to the notice of the election petitioner after file of the election petition. The said document is marked as exhibit so-and-so. That has been marked in the evidence, my lord. Now, my lord, this name, late Tai Nilo, is there in my election petition at page 497, serial number 18. No, serial number 13, my lord. Page 497, because I have given a list of dead voters, bogus voters. So dead voter under 16 Pagba polling station, serial number 30. So this is not beyond pleadings. I have pleaded that dead voters have come and voted, impersonation has taken place. I have given names, specific names also. By evidence, now I am only producing proof that what is going to prove that fact that he was dead. So this is material particulars. Material facts is already pleaded in the election petition, which your lordship has already held, my lord. So therefore, there cannot be an objection to this, my lord. Now, second document, my lord, B. Because I will just show, my lord, because most of them are death certificates, photographs. So if we take 2-3 documents, it will be largely covered, my lord. B, a copy of the death certificate showing the late Niag Yadik had passed away on 11/7/2023, but bogus vote has been cast against the epic number at 16 Pagba polling station. The copy of the said death certificate was handed over to the election after the filing of the election petition. The said document is marked as exhibit so and so. This name also, my lord, will find at same page 497 of the election petition at serial number 18. So this individual's death certificate I am placing on record. His name already I have pleaded. I have also pleaded that dead voters have come and voted, therefore impersonation, therefore, my lord, resulting into improper election results. So therefore, my lord, this is also there. Lordship may, serial number 18 at page 497. Likewise, my lord, C and D, my lord. C is basically videography, my lord, and the covering letter of the videography of the polling that has taken place for 3 polling stations. So this C has not been objected by the other side, my lord. It contains the videography as well as the covering letter of the actual date of polling, my lord. So C is not objected, my lord. D is also presiding officer's diary, my lord, not objected by the other side, because these 2 documents and videography was given to us by the order of this court, my lord. They cannot probably object, and they have also got a copy of this. E, my lord, is again a death certificate of late D.K. Tania, passed away on 11th November 2024. This name also, my lord, figures at page number 447 at serial number 17. Page 447, serial number 17.
Yes.
And, my lord, is a photograph of the memory stone of Tai Kelly at Naharlagun shows that he has expired on 1st of February 2022. However, bogus vote has been cast against the epic number at 30 Peel polling station. The photograph was handed over to the petitioner after filing of the election petition. The said document is marked PW so and so. This also, your lordship will find his name at page number 447, serial number 13, my lord.
30.
13. G, my lord, again a photograph of the memory stain of Tai Teli. This, your lordship, find at the same page 447, serial number 12. So nothing out of pleadings, my lord. Even the name is mentioned. So whatever document now I'm trying to introduce by way of 14.3 has been pleaded. Their names are also figured in the original election petition. H, my lord, is a certificate of Gambura of Roa village. So here also, my lord, certain names are there. He has certified that these people have expired long before the election has taken place, my lord. In this also, my lord, your lordship will find the names which are mentioned in that certificate are figures, some of them, not all, but some of them figures, at least 4 I could find at page 527. Serial number 15, serial number 18 to 20. So this certificate is also relevant because we have already pleaded their names, figures, and I'm giving certificate. Now, I, my lord, is a letter regarding the postal ballots. So, my lord, postal ballots at page 40 of my election petition, my lord, there are specific grounds taken that the postal ballots were incorrectly handled, incorrectly received, and resulting into incorrect conclusions. So that ground your lordship will find at page 40 Roman, paragraph Roman 23. So this postal letter by the, and this is an official letter. This is not my document. This is Election Commission document. So pleadings are there regarding postal ballots. Specific pleadings are there. And in continuation of that, I'm placing this on record. And this is not my document, an official document. The material facts have been pleaded. This is only in terms of material particulars, which I am entitled to do, my lord. Lordship would like to see that specific, my lord, pleadings. I can show, my lord, page 40 of the election petition. It is
Yes.
there. There are three specific grounds are there. Roman 23 to Roman 25. Lordship may make a note of that regarding postal ballots. Now, my lord, J is RTI application, which and its reply, which have been received regarding the gun transfer. My lord, what is the allegation? There is specific allegation in the election petition. There are 4 guns, licensed guns owned by the returned candidates. But in Form 26, it did not disclose any of them. So this is a material fact which might could have influenced the voters, my lord. He did not disclose any one of them. When we file it in their reply, in their WS, they say, no, there was no 4 guns, there were 2 guns. And just before election, when the code of conduct was in place, I have transferred it. Now, after receiving that reply, my lord, we have filed this RTI and we got this reply from the concerned police station because there is a detailed process, my lord. NOC has to be obtained and there is a process of transfer of gun and during election period, because normally, my lord, when election is declared and the code of conduct has been invoked, therefore you have to deposit the guns to the district administration. Instead of depositing it, it was transferred. So therefore, we have filed a detailed RTI and reply has been received after, Lordship will see 15th of April 2025 is the date of the reply. So this is after my election petition, my lord. So that I am on to bring on record. This is part of my pleadings, part of their WS in reply. So therefore, there is no question of going beyond the pleadings, my lord. In the WS, my lord, they have mentioned this at page number 571.
Yes.
Para, my lord, 27 Roman 3 in their WS. So all documents are connected with the pleadings of both sides. My lord, next one is K, again regarding the gun license, my lord. Another RTI filed regarding another police station, my lord. That also we are annexing. This covered by the same pleadings. That is serial number K, my lord. L is again, my lord, the memory stone. Until K, my lord, it is by PW1. All these documents are being exhibited through PW1, my lord. From L, it is PW2. So this is again memory stone, my lord, of so-and-so. His names figure at page number 447 at serial number 7.
447.
Page number 447, serial number 7. I'm sorry, my lord, serial number 9. I'm sorry. It is 9. Next one again, my lord, photographs. Same page, 447, serial number 7. Tai Yachek. So both in these 2 paragraphs below, the photographs were handed over to the election petitioner by Sri so-and-so after filing of the election petition. I've mentioned the name also, my lord. Now, N is again, my lord, memory stone. The name your lordship will find at page number 497. Serial number 13. This is that Facebook, my lord, the same person. I have filed 2 documents. One is the Facebook, now is the memory stone, photographs of the memory stone. This is through PW3, my lord. O is again, my lord, same photographs, page number 497, serial number 18.
18, you've said so.
Yes, my lord. This is also a repetition, my lord, because this is again, the death certificate is already there. This is the photograph of that. So same person, 2 documents. P is again, my lord, another photograph, page number 527. This is also, my lord, part of the Gaubura's letter, my lord. The certificate he has issued regarding the dead person. I am giving separate proof of their memory stone, photographs of their memory stone. So 527, same page nation. Serial number 18. Q also, my lord, same page. Serial number 19, my lord. And R, my lord, same page, serial number 20. And S also, my lord, same page, serial number 15. So these are double documents, my lord, same person, but then two different set of documents. Now, my lord, this is through PW4, my lord. So, my lord, PW1 is exhibiting 11 documents. PW2 and 3 are exhibiting two documents, my lord. And PW4 is exhibiting 4 documents, all connected with the pleadings. I have shown, my lord, the name, specific names are there and specific pleadings are there. First is the dead voter pleadings, my lord. Then the gun license and suppression of this fact in Form 26. And thirdly, the postal ballots, my lord. These are the broad outline, my lord, of the 3 grounds which I have taken specifically pleaded in the election petition. They have replied to that, and these are the documents. Now, my lord, one para, my lord, one judgment. In fact, my lord, the same judgment has been referred by your lordship also in the same 21st of March 2025 judgment, paragraph 41. The judgment is, my lord, Virender Nath Gautam versus Satpal Singh. 2007, 3 SCC. 2007, 3 SCC, page 617. Virender Nath Gautam versus Satpal Singh. You know, in the striking of pleadings, there was this argument, my lord, what is a material fact and what is a material
Paragraph?
paragraph, my lord, 34, 35. I will read out, my lord. Your lordship may have that judgment, my lord, 21st of March
Okay, it's
2005.
okay.
So there in para 41, and lordship has reproduced that.
Yes.
May I just read 2 paragraphs only, my lord? Material facts are primarily paragraph 41, my lord. Internal page 21, my lord.
It's 23.
I'm sorry, my lord. In my lordship has it 41. It's reproduced, my lord. So
Yes.
I'm reading 34, my lord, para. The material facts are primarily on basic facts which must be pleaded by the plaintiff or by the defendant in support of the case set up by him, either to prove his cause of action or defense. Particulars, on the other hand, are details in support of material facts pleaded by the party. They amplify, refine, embellish material facts by giving distinctive touch to the basic contour of the picture already drawn so as to make it full, more clear, and more informative. Particulars thus ensure conduct of fair trial and would not take opposite party by surprise. 35, my lord, it's important. All material facts must be pleaded by the party in support of the case set up by him. Since the object and purpose is to enable the opposite party to know the case he has to meet. In absence of pleadings, a party cannot be allowed to lead evidence. Failure to state even a single material fact, hence will entitle dismissal of the suit or petition. Particulars, on the other hand, are the details of the case which is in the nature of evidence a party would lead at the time of trial. So therefore, my lord, I specifically stress on this line, my lord, that material facts I have pleaded. I have pleaded dead voters coming and voting. I have pleaded gun license, suppression of gun license. I have pleaded postal ballots. All these are pleaded, my lord. These are facts. These are material facts. Now I am placing it through the evidence to prove my case. These are not material facts. These are material particulars. So this judgment covers my case, my lord. And my lord, there in the reply, my lord, what they are saying, my lord, basically they are saying this in broadly, my lord. They are saying there is no reference to of these documents in the election petition. There cannot be, my lord, because some of the documents came into existence after the election petition is filed. So there cannot be. And some of the documents, none of the said documents were included in the list of documents. It cannot be, because list of documents, when we file, these documents were not there. The election petition contains no pleadings connected with or based upon the aforesaid documents. These are three broad. But I have shown, my lord, that voter specific names are there. Electoral postal ballot specific pleadings are there, my lord. I have stated that.
But admittedly, you have not mentioned that, the documents,
I have not mentioned.
the documents.
Documents I have not mentioned, because those
Because-
documents, because one person is dead, my lord. I have pleaded that fact. That person is dead. I have pleaded that fact from my knowledge. Now from my after filing this, I am now placing the documents to prove my pleadings, because I have pleaded it. So once I have pleaded it, I am entitled to read evidence based on my pleadings. So that is what I am doing, and I am saying at that point in time I was not available. These documents were not in my knowledge or power. That 14(1) says it must be in the plaintiff's power or knowledge or in possession. So these documents were not in my power and possession at that point in time. It came after filing of it. So therefore 14(3), my lord. I'm seeking a leave of this court to file it, my lord. Even otherwise, my lord, regarding the Facebook page, my learned friend has taken an objection saying election petition is not a competent person to introduce or prove the said Facebook document. This is one objection. Second objection, the petitioner has not disclosed when and how the Facebook page came to notice. The author of the Facebook has not been examined as a witness. So these are all, my lord, subject of appreciation of evidence and admissibility. This will be decided by this tribunal at the time of cross-examination or at the time of final argument. At the stage of 14, Order 7, Rule 14, these are not the objections, my lord. But objections to the admissibility of a document or objection to the relevance of the contents of the documents is not the stage at Order 7, Rule 14, my lord. That is at the time of cross-examination, or that is at the time of argument. My learned friend will put question to the person who is exhibiting these documents. Where did you get it? Who has proved it? Are you the competent person? And relevance, your lordship will consider at the time of argument. So these objections cannot be to defeat my application and place it in record the relevant facts to the ends of justice, my lord. So, my lord, there is one more document regarding the death certificate. My learned friend has taken an objection, the non-disclosure of the date of issue of the death certificate. But I have checked the death certificate, my lord. It's on the face of it is mentioned when it is issued. Another objection is the death certificate was in existence at the time of filing of the election petition. But this is one statement made. So these are all questions he will put to the witness who is trying to exhibit that. These are not grounds to reject my application. So, my lord, regarding memory stone also, my lord, he has taken some objections that these are photographs from which camera these are taken. So I have annexed all certificates, electronic certificates along with those photographs from where it is taken. Those are there. If he has any objection to those, he can put to the witness key, where is it, when it was taken, how it was taken, how you maintain your records. Those questions are subject of cross-examination, admissibility of evidence and relevance of evidence. Now, my lord, one judgment of this court, my lord, on 14(3). Thank you. Your lordship will see at para 6, Order 7, Rule 14(3) is pleaded, is reproduced. 7 onwards, I'm reading, my lord. So on a perusal of the provision of law as quoted above, we are of the considered view that the document on which plaintiff ought to rely in origin in this case is not totally precluded to be placed before the court, even after the stage of the issues and documents. Rather, the legislature made a provision to file documents at any stage to meet the ends of justice. However, the document is to be filed or brought on the record with the leave of the court. Number 8, my lord, we do not see any reason how, if the said news items comes on the record at this stage, it will cause any prejudice to the respondent and defendants. Ultimately, it is the truth to prevail. This is more so as the respondent defendants had admitted the publication of the news item. We have also gone through the order dated so-and-so of the learned lower court passed on the petition so and so filed by the plaintiff under Order 7, Rule 14, read with 151 CPC, praying to the court to allow him to produce the original newspaper published or defamatory publication against the plaintiff and subsequent rejoinder of the plaintiff by the plaintiff and other against the same. The learned trial court below, however, came to the finding that at this stage, a plaintiff cannot be allowed to file the documents as prayed for. If it is allowed, it will cause prejudice to the defendants. Hence, learned court rejected. After going through carefully the appeal memo as well as the impugned judgment passed by the learned court below, and in consideration of the submission advanced by the learned counsel for the plaintiff, it appears that the whole case before the learned court below is on the basis of news item published in the daily newspaper called so and so, while deciding whether any defamatory statement has been published in the newspaper ought to have been allowed to be produced and considered by the learned trial court. It is a fact that plaintiff should have filed all the documents at the stage of issues and documents. In case he failed to do so, he could have brought the matter to the notice of the learned court below immediately after framing of issues and documents or at the stage of evidence. This is after the stage of evidence, even worse, my lord. Still the court allowed. However, the main issue before us is whether or not placing the news item before the court or failing to produce the news item.
No, it's not at the stage of evidence.
Yes, my lord. In case
After the stage of evidence.
yes, my lord. If it says, my lord, even after the stage of evidence, it can be allowed, my lord. That's the meaning coming out, my lord. However, in the main issue before us is whether by not placing the news items before the court or failing to produce the news item in appropriate time, it is enough to dismiss the suit when publication thereof is admitted by the respondents. In our considered view, the learned court is to render substantial justice. It is settled principle of law that mere technicalities, a court should not reject the plea, otherwise legally sustainable. A court is duty bound to render substantial justice and not shut the door of justice merely on technicalities. Therefore, after going to the facts of the case and impugned judgment in question, we consider that it would be in the interest of justice, the appellant is given a chance to produce the daily newspaper. The suit was dismissed, my lord. After that, this was allowed. This application was allowed, my lord. So here in this case, my lord, we have filed it along with my application. The evidence was filed on 24th of October. This application is filed on 23rd of October along with the evidence. So there is no delay. Even there was a delay in this case, still the court has allowed that. And my lord, there is a perimeter provision is Order 8. For the defendant also, similar provision is there, my lord. This is that Supreme Court judgment, my lord, 2020. Sir. Identical provision, my lord, perimeter provision. Para 9 and 8, my lord. 9 and 10. This is, my lord, Order 8, Rule 1A. This is identical for the defendant. So almost identical perimeter, 9, my lord. It is often said that the procedure is the handmaid of justice. Procedure and technical hurdles shall not be allowed to come in the way of the court while doing substantial justice. If the procedural violation does not seriously cause prejudice to the adverse party, courts must lean towards doing substantial justice rather than relying upon procedural and technical violation. We should not forget that the litigation is nothing but a journey towards the truth, which is the foundation of justice, and court is required to take appropriate steps to thresh out the underlying truth in every dispute. Therefore, the court should take a lenient view when an application is made for the production of documents under Sub-Rule 3. Coming to the present case, the defendant have filed an application assigning cogent reason for not producing the documents along with the written statement. They have stated that these documents are missing and were only traced at a later stage. It cannot be disputed that these documents are necessary for the arriving at a just decision in the suit. We are of the view that the court below ought to have granted leave to produce these documents, my lord. So therefore, my lord, in my case also, my lord, I have pleaded all these facts. Even the names are also pleaded, my lord. That time I did not have the documents to file it along with the plaint. Now I have got the documents and I am filing it. As regards gun license, my lord, these documents came into being after filing, my lord. And they are also in their WS saying, yes, there are gun license. So therefore, and he has transferred. So therefore, these documents came into existence after, and they're also admitting to this fact. Yes, I have transferred. So they are documents, my lord. They have transferred it. So they cannot deny these documents and no prejudice can be caused to them by this. And thirdly, my lord, even regarding postal ballots, my lord, I have pleaded 3 paragraphs detailed, page 40, Roman 23 to Roman 25. I have pleaded specifically, my lord. And therefore, my lord, I am placing Lordship may grant leave in this case and the matter may go for evidence, my lord. Subject to my
How's your
Oh.
health, sir?
Will not heavy doses of antibiotics for more than a month, so naturally the weakness will not go easy. So that is there, can't help it.
Are you comfortable today? Are you comfortable today?
I want this at least to be over today. Now, my lord, there is no quarrel with the fundamental proposition, namely that the procedure is the handmaiden of justice, and that justice cannot be at the mercy of the procedure. But here, my lord, I will try to demonstrate, number one, as to how the prejudice has been caused. Number two, the fundamental error that has been committed, my lord, in the present case by way of these additional documents. And thirdly, my lord, as to how, my lord, in certain cases, they have traveled beyond the very scope of the provision itself. It is indeed true that some of the documents certainly can be, my lord, maybe given to him in respect of some of the documents, but in case of some other documents, possibly it may be difficult. And I will show why it may be difficult. Now, before I do that, let us, my lord, take note of certain very important factors. Namely, total 19 additional documents are being sought to be introduced by way of this IA. The leave is being prayed for introduction of 19 documents. It is correct that out of these 19 documents, 11 additional documents are being introduced by PW1. PW1 is the returned candidate. 11 documents. Whereas the PW2 is introducing 2 documents, PW3, 2 documents, and PW4, 4 documents. So far as PW2, 3, and 4 are concerned, in their cases, while filing their evidence on affidavit, the photocopies of these documents are there.
2, 3, 4.
Yes, PW2,
3.
PW3, and PW4.
Huh.
Their evidence on affidavit, the photocopies of these documents are annexed. So we are not taken by surprise, at least we know what these documents are. This is going to be my first objection. I'm making it. So in their case, we know, yes, these are the documents. But look at the irony. So far as the 11 documents are concerned, which are being sought to be introduced by PW1, neither, my lord, in the evidence on affidavit of PW1, the photocopies of those documents are there, nor even in the interlocutory application. The point I'm trying to make is, at least for the purpose of adjudication of this application, this IA, annex the photocopies of those documents so that we see what these documents are. 11 documents, they have given the narrative. This is the document, this is the document. In their evidence on affidavit of PW1, they mention these documents. They don't annex the photocopies also.
Sorry to interrupt, but
To grant the leave
is
or
there, my lord, in the PW1,
not there.
page 55, I have annexed it, all the documents. Page
My lord,
55 of my PW1 evidence.
this is the PW1 affidavit. And my lord, there is not a single annexure here.
No, lordship, I see it's there.
No, but if you don't give me the copy of,
Yes.
sorry,
Copy I will give, but we have filed, we have given copies also.
this is the copy, sir.
No, it's not correct. I don't think-
Correct, but this is the copy.
This is a very hyper-technical ground.
Sir, no,
Lordship, I see page
That's the very
55.
concept of
Yes, sir.
prejudice.
He should have asked me then if he
How
said,
do I know? I
why
thought-
did he accept, how can he accept the
How
document?
I accept the, he
But
does
he-
not accept the
But
copy.
then,
This is the
if it's
copy.
an incomplete copy, he should have immediately told me, below. This is only delaying technique. This is a delaying, below. He should have told me, I would have given him,
Sorry, I'm sorry
if it is
to
not
say
there.
this.
According to me, I have given complete. He
Suppose
should-
if documents, these documents, if I find that is allowed to be introduced or relied upon, I mean, file, in fact, they're not able to dispose of the matter goes in your favor. So that during the pendency, you could have these documents. So delay is not, I mean, delay is not in his favor, delay is in your favor. If these documents are allowed.
Yes.
Suppose if we decided the matter, had we decided the matter within 6 months, these documents would not have been here today. It's not it. So on lighter note, I'm saying, delay whatever may be. I mean, it's beyond our control. First day also we thought we'll just finish it within not 6 months, at least within a year.
No,
But now it's nearly 2 years.
July it will be, kindly have 55, page 55. मैं खाली उस पे दिखा रहा हूँ, sir, क्योंकि
Yes.
document अगर है कि नहीं.
Sir, it has been annexed.
But not if it is my copy, it is, there are,
Well, he should-
Why you have not given?
I'm very,
the documents are there.
It's reminded me in a district when there was when the deputy commissioner in the state of Arunachal Pradesh were the session judge, lawyers used to file only petition. It's annexed. It is mentioned. They refused to give the annexes.
It happened, I know, so many cases.
Then in that case, we also do, we refuse, we note it down, key annexures not given. In the receiving, we note it down, annexures.
No, that
not-
was
page
something
number
different,
12 to
but
receive.
we failed to, we didn't know what is the procedure at all.
So, Milord, if without, madam, I trust, believe my learned senior colleague, Milord, I am not, I will, Lordship may fix it tomorrow, I am giving a copy right now, only on this, if he wants, if he can still lead his argument, in absence of that. I am very sure about his,
Right now.
please.
I'm taking, what is the purpose here, Milord, behind it? No,
Lola.
I proceed further. Let me, thank you very much. This is it. Please keep it. See, Milord, now these dates are
No,
relevant.
you will not say that you have not been punished.
He has given to me, Lordship will record it. In
Then
course of the proceeding.
you go through it and we'll take it some other day.
Milord,
It would be better because tomorrow if he says, because you are also admitting that it's not been punished with these
no,
documents.
I'm not, Milord, I'm giving an additional copy.
No. Otherwise also, yes.
No, I'm not saying, I'm saying, I'm giving, since my learned friend is saying he has not received, I bow down to that, there's no problem. I'm giving additional copy. It doesn't
you're-
mean I have not given earlier.
See, Mr.
Will not-
Tiwari, if you are relying that you have not been punished, and since though you has it punished today, you go through it, you will have it thing because you will be taking the same ground.
Milord,
After 26 January.
can it be, it's a short matter, Milord,
Short,
because
like
the
26
evidence,
January.
because again, I have to come, Milord, that's all.
What's
because-
there, you will have to come.
Delhi is very cold, Milord, I'm sure my
Well,
London
traveling
friend.
around.
Because I'll go through the entire, each and every document I will examine.
Can it be, Milord?
Because I don't want
After
to.
26 January, don't make it because I can't. After 26 January.
The seem to be that the other party has been deprived of having, because the first ground is that. First submission is that this has not been annexed. He said for the PWS 2, 3 and 4, no issue. It has been annexed. Only one. So you might not have done it intentionally, right, Mr. Rituraj? You might not, it happens.
No, should be there, I'm taking this now.
Milord, I'm only saying, Milord, can it be before the vacation, Milord, so that I can.
Was it before the vacation, day after tomorrow?
After 26 January, it's not like.
Only we have 4 days this thing.
Milord, I was here,
Tomorrow,
Milord.
tomorrow and day after only.
So
Not
day
reason-
after it fixed, and I'm here, Milord, so I can.
You know, reason is there is contempt on 23rd,
Milord,
which is.
my friend is always busy, Milord, I know, Milord, but he must be, he's
Maybe
in.
because more than a month I have
Milord,
not had
I'm here,
nothing.
Milord,
Let us make
The
it.
reason is for
we
more
make
than
it
a month,
27.
nothing happened.
27.
Yes.
We'll finish of 27.
27.
At least the hearing will conclude,
Yes.
subject to,
Yes.
I mean,
27th, I'll finish it. I'll just go through it.
I think,
It will not be done, I'll tell him. 27, he says, no, I will not do that case. I'll be here
But-
before the Lordship.
it's here,
27th will
only. It's here. Documents they have annexed.
Yeah, but will not- I'll go through now.
See, you'll have to have this. How to get his, all this thing. We'll have to. We'll tell him to do it or we'll do it. We'll do
वो तो बोल रहा है कि आपको दिया है.
Yes, sir. Original. Original is there. Okay, this photography. huh?
के पहले से हाँ?
Ready.
I have in fact, I've heard you, it's only his part.
His part.
For I.
27th, Lordship may fix it.
As usual, you may have the synopsis also.
Sure.
Written, okay.
Get it done.
Yeah.
So that especially for this court is more convenient. Because of the lengthy, I mean,
I'll do that. My lord, I also, it's good that my lord has pointed this out. I will do that.
it's convenient for all of us. Okay, then. Aye, huh? And Mr.
In case.
Arbishwas and Mr. DJ Kapit learned consent for the applicant election petition, huh? And Mr. Piketty learned senior counsel assisted by Vincent for opposite party respondent, huh? We'll say the hearing will continue
Continue.
on and according as agreed to by list the matter on 27/01/2025, 26. Election petition, list along with sides. Election and REP.
I got the sad news, my lord, this morning.
We'll finish it off on
Yeah.
at least the hearing order. I'm not sure, but the hearing will complete on 27. Once we finish it, we can proceed
Okay.
with the evidence.
Evidence, sir.
Yes, yes.
Right. Along with this, we have given some pen drive also along with PW1 because there is a videography. That my learned friend has received, not received pen drives.
नहीं
Because
कुछ
pen-
नहीं भाई.
This is
Really?
I personally handed him the pen drive
To Rinchen. Okay.
because he was there. Everything was given to you.
But not everything otherwise. PW.
Maybe, Mr. Tewa, sir, maybe they might have provided there.
Yes.
I am also on the photocopy only. It's got torn, everything is torn.
Pen drive is there.
So how do arrange this voluminous thing to have this binding kind of thing? Will be at the cost of the petitioner or the, I mean, for the parties or the,
Sorry, Minute.
we need to bind this documents,
Yes.
evidence and all, because everything is,
But fine.
Yeah.
We'll do it. We'll do it. We'll
I think
prepare.
it's better.
Is over. Then paper-
Evidence is over. Evidence cross-examination and.
No, at least this evidence also, affidavit, evidence. Because it gets.
So, Milord, once the evidence is done, Milord, along with the affidavit, we will annex the cross-examination part.
No, I'm just
Prepare
suggest-
separate.
It's all, that's the
Prepare.
procedure.
Prepare.
Okay. Okay, 27.
We will do it. We'll do it.
Learned the sad news today. In fact, Mr. Shabdaraba is no more. In fact, I learned today.
Yes.
Mr. Shabdaraba, the
Yes,
concerned
yes.
advocate. In fact,
Very unfortunate. You
he
never
died
know.
very young, in fact, in his early 50s.
Okay. Great.
Okay. Note before में क्यों है? Note before में लगा हुआ है. वो अलग से दिया है.
Well, please, Your Lordship. My lord, I filed amendment petition, my lord. I am to file the consolidated petition, my lord. That could not be filed in time, my lord. Some time may be granted. It may come after next week, my lord.
Amendment has been allowed.
Amendment allowed, I am to file the consolidated petition.
Then what is this IA for?
I am on that, IA was that regarding this filing of the petition, my lord.
That has been disposed of also.
Not disposed of.
You have filed the
My
writ
lord, in
petition.
this IA, it is directed that I should carry out this earlier order. That earlier order was for consolidated petition. Amended petition is to be filed. So some time may be granted to file this consolidated petition, my lord.
I could not understand.
My lord. I filed an amendment petition.
No, to your submission, I've understood.
No, no.
By this IA, I could not understand what you want. Because this IA is filed in a disposed petition. This is disposed.
Read petition is
Read
disposed.
petition was disposed.
So,
of.
Then what is the question of the consolidation? Consolidated
Amendment
petition.
because, my lord, in the order, there was some mistake. my lord.
Yes.
so therefore, that error crept in the order also.
So how you can,
So I filed this amendment petition, my lord.
this is amended petition.
My lord. No,
Huh?
my lord, amendment petition filed, my
This
lord.
is IA is for,
File, IA is for
Correction of order.
correction of order, my lord.
so this is listed
No.
today.
It is listed
So
today.
what's the
in
question of
correction of
allow
order.
time
But
to file
correction
a?
of order, your lordship passed an order that correction of order cannot be done
Hmm.
without filing the consolidated petition.
The stage is over now. Writ petition has been disposed of.
Read petition is earlier disposed of, my lord. In
Then-
disposed of petition, I have filed amendment petition.
Then,
Disposed of read petition, I have filed amendment petition. That was
Thereafter-
allowed by your lordship.
but amendment was allowed, but you have not filed
Now
consolidated
I am to
petition
file the consolidated petition. In the
in a
meantime,
dispose of matter.
Yes, my lord.
That cannot.
But that has been allowed by your lordship.
Which one?
What petition I have been filed for
Ah.
amendment of the disposed of read petition, that has been allowed by you.
Where is that order?
Yes. my lord.
where is that order?
Order in the earlier miscase, my lord. There are two miscases.
How how it can be allowed? In a disposed writ petition.
Disposed read petition, it is allowed.
IA, which IA?
My lord, IA number is not available.
3825.
Record is not available with me, my lord. So sorry.
Praying for amendment writ in suspect changes sought to be withdrawn. Sought to be withdrawn which are narrated in period. They are necessary to be recalled in the writ petition. Yes, this amendments were allowed when the writ petition was pending
No, my lord, after disposal.
after the.
My lord, what happened? After obtaining certified copy, we noticed that there is some mistake in names, my lord. That is our mistake, my lord, in the cost title. So that was allowed. Now we are to file the amended petition, my lord.
When the writ petition was disposed of?
My lord, writ petition copy is there. I am sorry, my lord, the record is not with me.
Sir, how you are submitting without record?
In that case, my lord, day after tomorrow, it may be listed. Let me come with record. my lord.
When the writ petition was disposed of?
By the writ petition copy to the end.
8/11/2024. How this could have been allowed? Under what provision this has been allowed?
My lord, I filed the petition. I filed the petition under Article 226 and Order 6, Rule 17, CPC.
I'll not be able to
My lord,
grant you any relief.
my lord. Because, my lord,
On the prayer of Mr.
now, my lord, what happened?
MSEC, learned counsel for the applicant, list this matter after 4 weeks. It's better.
My lord,
How the amendment can be allowed in a disposed writ
my
petition?
lord, it is not a point for argument. Then also, my lord, I want to
no.
clarify
It's
before
a
your
question.
lordship.
It's a procedural law. It's a
My lord.
question of law.
My lord. Now, what happened, my lord?
Can you
as
show
it
me
was-
any,
as
any,
your-
pro-
as your
can
lord-
you show me any provision or any law?
As your lordship already allowed, so there is no point of clarification of.
That's why I'm asking how it has,
Now,
how it
my lord,
could have been allowed.
let me try before your lordship.
You find out.
That action.
You find out the law and the
under CPC.
procedure, please.
No, my lord, under CPC,
And
two
the,
26
Mr.
petition. My lord, under CPC, 226 petition, 226 petition and writ petition is not a miscellaneous proceeding. Your lordship has got power. No proceeding of CPC will not apply here. It is up to your lordship.
It will not apply in
It will not apply. Your lordship can.
it may not apply in
In the
the
interest of
letter, by spirit will apply.
My lord, that's
And
all.
we have a set of High Court rules,
My lord.
right?
My lord, there is no bar in the High Court rule that they dispose of petition.
No, it's not the question of bar.
My lord.
It has to be supported by the law or the procedure.
For the interest of justice, my lord, your
No,
lordship has got power.
This is not.
My lord.
Otherwise, Lordship, in the disposal of writ petition, direction was given to submit him a fresh representation before the authority.
Paragraph 12.
Paragraph 12.
No, that is not, I'm not interested. My interest is, concern, our concern is, all of us, how a amendment can be allowed in a disposed of writ petition, which is no longer there.
My lord.
And maybe, he may be correct, we have allowed it also.
Yes, ma'am. No, but on that count, my lord, I want to submit before your lordship. There is decision that even in any stage, amendment can be allowed. Even in appellate stage also amendment allowed by the court.
In it,
Yes,
this
type
is
of
not an
decision is
appellate
there.
stage.
yes.
It's not an appellate stage.
No, my lord, appellate stage means when it can be after disposal, meaning thereby after disposal, it can be amended. How appellate court can amend? Because it is already the suit is.
Mr. Sheikh,
My lord,
let us go by the law and the procedure.
my lord.
I also believe that this court has considerable knowledge of the law and the procedure, like you.
Definitely,
So let us not be too blunt
my lord.
on the basis of your case.
My lord,
You are the officer of the court,
my lord.
right? I just wanted to know, I wonder how it is can be allowed.
But your lordship.
Thank you
allowed-
for after 4 weeks.
My lord,
Think about it.
my lord. In that case, my lord, it may be placed before the appropriate court. How
No,
it is allowed.
no. I am not the
And
authority.
when coordinate.
I have no power.
My lord,
It will be
When-
listed before the bench
my lord, when
as and
coordinate,
when as per the roster.
when
right.
coordinate.
Maybe this court, maybe that court, maybe wherever.
My lord, when coordinate.
So we're
allowed, my
equal,
lord.
we may have a different opinion, but then we're equal.
My lord.
And then as per the rules and the procedure, this court has no authority to transfer and get it listed before any other bench. It is the master of the roster. Authority is master of the roster with the master of the roster, right?
My lord,
Thank you. Think about it.
my lord.
Yes, madam, what is this? What is to be done?
May I please, your lordship? Lordship, they have filed their affidavit. Today we have
Yes.
received.
Okay.
Time may be granted. to
Okay.
file reply.
On the prayer of MS so-and-so learned counsel for the petitioner, list this matter after 3 weeks so as to enable her to file affidavit in reply. Yes. Mr. B. Das, State Counsel.
Private respondent number 8.
Respondent number 8. And who else are Chetia? State Counsel are present. Huh? Yes.
Let's
Hmm? Record the name. Are present JND. Standing Counsel Revenue Department, Chetia State Council, Government, and Mr. Bidas for a prior respondent number 8 are present. Huh?
Vice Lordship.
Met Mr. Lordship. Lordship, with the last order, 4/12/2025.
Yes. Then we are directed to produce original record. Also, they have communicated because it's an old pending matter. So they're not able to tracing it out, Lordship. They sought for some more time, Lordship.
Will release from the Parhat.
Yes. Lordship.
What to do? We said no further adjournment.
But thing is that, Lordship. Finally. They are also trying their best, Lordship. Okay.
It's of no use passing order that no adjournment shall be granted. It's a violation of the, will take a sumoto contempt.
Lordship, actually.
The lawyer, Mr. Naik. Where is P. Naik? I'm issuing a notice. We are taking sumoto contempt against P. Naik.
And on the subsequent 2 days, Arthur entered on behalf of P9, which was in post to P9. So there was some misunderstanding between order was filed, P9 was to produce relevant records. However,
Yes.
PC was to produce relevant records.
From that.
I am not passing any order now.
Lordship.
With the understanding that no adjournment at all shall be granted on the next date. Right. 45 days. You are seeking 45 days. 40 will grant 45 days.
Too long. Lordship, can we have 4 weeks, Lordship?
You said 45 days?
If 45.
Okay, heard, Mr.
Yes.
PK Dekha, learned counsel for the petitioner. Petitioners.
Yes.
Petitioners. This court. This matter has been taken up, heard and taken up, and this matter has been heard on many occasions. Finally, on 04/12/2025, on the prayer of Mr. P. Naik, learned Additional Advocate General, come Standing Counsel, PWD, granted 3 weeks time to 3 weeks time to produce the record with a condition that he shall produce the same finally invariably produce the same on invariably produce the same today. Mr. However, Mr.
SR Borua.
S.R. Borua, learned State Council and MS, appearing on behalf of P. Naik, learned Additional Advocate General, were placing the communication dated 02/01/2026 from the Additional Deputy Commissioner, Kachar District, submits that 4 weeks time may be granted to produce the records as sought for, as the authorities, responding authorities are in the process of tracing out the record diligently. List of having next para. Although no further time, this court is not inclined to grant further any more any further time. However, considering that the record would be required for proper adjudication of the matter, as a last chance, the learned State Council, the Advocate General, the London Additional Advocate General, Mr. Nayak and Mr. S.R. Borwa, London State Council are granted 4 weeks' time to place the record.
On 24th February, my lord.
24th
February.
MS G. Again, London CGC. And Mr. J. Henry and so are present. As agreed to by Learned Council for the parties, let this matter be listed on 24th
February.
02/2026.
24th.
The matter remains part hard.
Yes.
24th 02/2026.
Deeply obliged. my lord.
Yes, who is the petitioner?
Appears.
Yes, Laskar, what to do?
It may be given.
There is no interim order. So we'll dismiss it. None appears for the petitioner on call. No, there was no fixed date. Okay. Anyway, none appears for the petitioner on call. Petitioner, sir, on call. Mr.
Corporation Department.
Ah.
K. Sodhil on behalf of SK Talukdar. Respondent
Talukdar.
1, 2, 3, 4, 6, and 7.
And Mr. I. H. Laskar. M.H. Laskar, sorry. You, last order is there, are present. In the interest of justice, let this matter be listed after 4 weeks.